Are you muted?
Good morning. Can you hear me?
Yes.
Great.
Yes.
Good. Thank you. Mr. Malone, I'm going to continue with some questions. I'm turning now, Mr. Registrar, to OD6, page 35, paragraph 75, please. Thank you. So we're in July of 2013, picking up from yesterday. Your colleague, Mr. Appleby, sent a copy of the PowerPoint presentation that we were discussing at the end of day yesterday and the minutes to individuals at the city, including Gary Kirchnopf. You're not copied on this message, but Mr. Appleby invited review and comment on the documents. Registrar, can you close that and call out paragraph 76, please? Did you know Mr. Kirchnopf?
Yes.
Did you know him through SEMA's retainers and projects for the city or in some other capacity?
I knew him when I worked at the city. He reported to Hart Solomon, and his workstation was close to mine. I'm not surprised he was connected to this project in some way. So he was part of the traffic group.
So you'll see he responded to Mr. Appleby, and if you can just take a moment to review his response, he's directing Mr. Appleby, or he's inviting Mr. Appleby to contact Ludimir Mizarowski at Golder and Associates directly, should you require any additional information regarding weight in motion, quote unquote, or friction testing, quote unquote, on the main line. You weren't copied on this message either. Did anyone at SEMA bring the information contained in Mr. Kirchnopf's email to your attention?
No, I only became aware of this email upon review of materials provided for the inquiry.
Did you know that the city had retained Golder Associates to, quote, oversee all testing and monitoring of this specialized surface material, end quote, as Mr. Kirchnopf puts in his email?
No.
Did you have any contact with anyone at Golder Associates in 2013?
No, none at all.
To the best of your knowledge, did anyone at SEMA have contact with Golder in 2013?
To the best of my knowledge, no.
Did you have any discussions with Mr. Appleby about Golder Associates in 2013?
Sorry, could you repeat the question?
Did you have any discussions with Mr. Appleby about Golder Associates in 2013?
About Golder? No, none at all.
Did you have any discussions with staff at the city about Golder doing friction testing?
No, none at all.
Thank you, Registrar. Can you close that call out and bring up paragraph 78, which is page 35 and 36? Thank you, Mr. Malone. Is that readable for you?
Yes, that's good.
Great. So this is still in July of 2013. This is after the PowerPoint presentation that we were discussing. And Mr. Appleby writes to Mr. Cooper to see if the city has any comments on the proposed countermeasures or the minutes of that meeting on July 3rd, and indicates that he needs to do a final list of countermeasures to do the calculations required. Now, those calculations, that's the cost or the benefit cost calculations. Is that right?
I assume so, yes.
Can you close out that call out, Registrar, and bring up SIM 8266? So this is the email that that was just summarized in that paragraph we were just looking at. And you'll see that Mr. Appleby in the third paragraph says, because the geometric changes are generally off the table, we don't need construction costs. So just to confirm, SEMA was not intending to do any benefit cost analysis for geometric changes. Is that right?
Yeah, the paragraph sentence represents that geometric changes would be beyond the scope of the assignment. Similar to illumination that we discussed yesterday, the geometric alignment had been determined previously, approved through the environmental assessment process, and was not something for which this report would be capable of providing changes to. That's common for a road safety assessment.
Okay, so you just referenced illumination. Just staying on geometric design for a moment, you were and your colleagues at SEMA were quite clear that geometric changes were outside the scope of this project, right?
Yes, I mean the road had a curvilinear alignment with horizontal and vertical curves, and potentially theoretically making the road straight would be a safety improvement, but that was beyond the scope of what could be done within the bounds of this assignment.
Okay. In the second paragraph, it says we need a determination of costs. We can utilize MTO costs. We will for illumination as discussed. So at this point in the process, in mid-July 2013, Mr. Appleby and others within SEMA below Mr. Appleby, they are doing the benefit cost analysis for illumination using MTO costs. Is that right?
That would appear to be so, yes. And illumination was included. We were certainly analyzing illumination and dealing with the ramps.
In the third paragraph, at the last line, it says, Mike also said he had something to provide on illumination that he was going to give to you to provide to us. Did you receive this from him? Do you know what Mr. Appleby is referring to there in respect of Mike providing something, had something to provide on illumination?
No, I don't precisely know.
Thank you. Registrar, can you pull up OD paragraph 79, please? Sorry, OD 6, page 36, paragraph 79. No, I think we're on the wrong place. Can you cancel that call out? OD6, page 36, paragraph 79. Thanks. So this is, as I reference here, the individuals, this is an internal SEMA email. And you'll see that Mr. Appleby is providing some background. The second paragraph, the bottom paragraph here, also they're not keen on any high friction pavement treatments on the main line, but they are okay with it on the ramps, i.e. ramp 6. So we don't have to cost the main line high friction out either. So just stopping there, we spoke about high friction application yesterday. Can you confirm whether skid abrading is a high friction application that SEMA was considering?
That would not be what we would have been considering. We were considering more of an overlay material or some sort of material added on top instead of a attempt to retrofit to the existing materials. And excuse me, I'm sorry, could you reduce the size of the call it a little bit. It's being blocked by the video on the side. Very good, thank you.
So it was your thinking was to put something on top of the pavement, not to change the surface of the pavement to give it additional frictional qualities.
Well, the intent was to change the frictional properties, but not by modifying only the existing surface, but addition of other material. We had worked on other projects in the past where high friction material had been added to an area for bike lanes, for example, but it was a slurry material with high friction aggregate incorporated in it, which was added onto an existing asphalt, and that's roughly what we were contemplating.
Thank you. Registrar, you can close that call out. You can go to the next image and paragraph 82, please. So here, this is just to reference the time. This is July 26th. You provided comments on the draft report. This is before it's gone to the city, just to orient you in time. And I'm going to bring up the document now that you commented on. Registrar, it's CIM 369, and I'd like it in native form, please. Thank you. Registrar, can you scroll down to page 7 of this document, which is page in the pagination, page 1. And if you can, sorry, one more page up. Perfect, thank you. So Mr. Malone, I'm just taking this, you to this so that you can see a copy that has the comments in it. So you'll see that there's text boxes, comment boxes on one side from your colleague, Dr. Hadiagi, and then there are track changes within the document.
Sorry, I don't see any comments on the side.
Oh, it may be the way that your Zoom is oriented.
I see a banner on the right side of the page, but there's no text populating it.
If I can interject, I had the same problem, but it's solved very quickly by going into the top under review, going to all markup. And if you get the top-down menu, under the top-down menu, all markup, there's a box to click for all markup, and it will appear.
Registrar, can you complete that on the native version that you have up?
Yeah, I don't seem to be able to do that from Zoom, and I don't have access.
No, only the registrar can do that. Now, I am seeing it on my screen, so I actually think it might be a Zoom issue rather than an issue with the document. Mr. Malone, can you see in the left-hand side, it says navigation, and it has,
Oh, there we go. Okay.
there we go. All right. Yeah. So I think it might just be the way that your Zoom is
Yep. Sorry,
set up.
it's a size thing. If it could be reduced just slightly, they were hidden under the video on the side.
There we go. Is that better?
Better, a little bit smaller would be even. I can only read partial.
Mr. Malone, you also may be able to go up to the top of your Zoom screen and change the view. This is just as a matter of Zoom. You can change it from you can change it from whatever it's on to side by side. And I think that that might change the issue with the tiles covering some of the document.
I think we're good now. I can read them now. Thank you.
Great. Okay. So this is the native version of this document, and you'll see there's Dr. Hadiyagi's comments in the comment box on this page, and then there's track changes. Registrar, can you hover over where it says in safety in the paragraph immediately before to study objectives and limitations? The red track changes that say in safety. So you'll see, I'm just bring this to your attention. This is, you're identified as the author of the track change in safety in red. So all of the track changes here in red are yours, and the blue are your colleagues.
Yes.
Okay. Thank you. Registrar, can you turn up page 3, which is image 9? And apologies in advance in using the natives. I'm likely going to refer to the page numbers as well as the images. Perfect. Thank you. And if you could just go up. Perfect. So you'll see under study scope and study area, it says study scope, and it has the list of the scope of this study, including the review of various factors, collisions, signs, human factors, etc. It also says review of illumination, and then development of a list of viable potential countermeasures you've added in, viable, an assessment of countermeasures, cost-benefit analysis, and recommendations. And that's similar to the tasks that we went through on the RFQ yesterday. You see that?
I do.
Registrar, can you turn to page 16, internal page 16 of this document? Sorry, I know working with natives is a little more fiddly. We'll just give the registrar a moment.
And we lost the registrar. Oh, there he is. Okay.
Thank you. And registrar, can you just make that a little smaller so that we can see that we're on page 16? Mr. Malone, is that readable for you?
Yeah.
Well, there's some call-outs, but
The very bottom is cut off of the video, but that's fine. I can read it. Yeah.
okay. So I'm just taking you to the illumination review section, and you'll see your comment. on the right-hand side. Mr. Registrar, can you click on the comment just so you can see what the comment attaches to in the document? So you'll see illumination is highlighted there. So that's what this comment is attached to. And it says must add limitations that exist. I think it's with respect to lighting that we know from EA approvals. You didn't have any of the actual EA approvals at the time that you made this comment, right?
I had been told the EA approvals by Mr. Moore.
But you didn't have the approvals themselves, any documents about the EA.
We had virtually no documents relating to the design or approval of the freeway provided to us by the city for this assignment.
Okay. Registrar, can you go to the next page? Thank you. And at the bottom, you'll see illumination results. Registrar, can you call out 4.4.2? Thank you, and scroll down. Thanks. So here it says the full illumination justification was completed for 3 interchanges, Dartnell Road, Mud Street, Green Hill, as well as for the entire study area. And then if you can just scroll to the next page, Registrar. Thank you, that's perfect. And if you can click on Mr. Malone's comment, the first comment, and that's attached, you'll see to area is illuminated or is highlighted. And you say, we can't conclude this if there are specific constraints on the study area, which we previously acknowledged. At the least, we must follow this conclusion with recognition that the achievement of the warrant does not mean that they are being recommended. They need to be assessed in relation to the approval's constraints. At this point, had you discussed these comments with anyone at SEMA?
Sorry, discuss the comments?
Discuss your commentary that's in these comments with anyone at SEMA.
Well, that comment in particular, as you can see from it, is a response to a comment from Dr. Hadiagi. He said, shouldn't we talk about the environmental constraints? Didn't we get a report that highlights that we cannot do full lighting? And then my response is yes, we can't conclude, and so on and so forth. So it's a response to the input provided by Dr. Hadiagi, recognizing, understanding that there's some environmental constraints there that are in place with respect to illumination.
Thank you. Sorry, let me rephrase my question. Apart from the back and forth in written comments in this document, had you had oral discussions with your colleagues about this before this this back and forth in the document?
Well, I think it's important to have some context of the document. This is, in my understanding, this is version E00V01. So it is the very first draft of the report being prepared internally by SEMA. Nothing has been distributed to the client yet, gone outside SEMA's doors. For a report of this nature, the various components, the sections are compiled by different authors. So as I think we discussed earlier, some people were looking at the collision information, others at illumination, others at various volumes and speeds and such. So there were various authors that wrote individual sections and pieces, assembled them into this one piece, and Mr. Appleby has put this together as the rough first draft. I had the discussion with Mr. Moore, and I don't remember precisely who I spoke to. I'm pretty sure I did not speak to the entire team, every single person working on it, but it's pretty clear from the notes here that Dr. Hadiagi was also aware of the same information that I was from the conversation with Mr. Moore, which we understood to be the direction from the city.
Thank you. Do you know how Dr. Hadiagi was aware of the same information that you were from your conversation with Mr. Moore?
I can't speak precisely how he became aware of it. I assume I spoke to him, but I don't really have a recollection of that. You could speak to him if he has a more clear recollection.
Thank you. Registrar, can you go to image 42, which is internal, page 36? Thank you. Can you go up to the top of that page? Apologies, Commissioner, just give me a moment. I don't think I have the right page reference. Apologies, it was page 37. Thank you. In the draft prepared, or at least compiled by Mr. Appleby under 6.1.1, the draft that you are commenting on says the outcome of the TAC illumination more indicated full illumination on the corridor and ramps is justified. And that the cost benefit ratio was 4.27, and there's an indication of the expected service life for this countermeasure as being over $4 million. You provide two comments here. One is we must balance this off with a clear understanding that we're not suggesting consideration of full illumination. Now, why was that? Why were you suggesting, or why were you commenting that we're not suggesting consideration of full illumination?
I think it's consistent with my explanation earlier that my understanding from the direction provided by the project team to speak to Mr. Moore and the clarification provided by Mr. Moore was that illumination through the valley was not permitted under the environmental assessment rules or approvals. And so in my understanding was that illumination in the valley, which would be on the mainline component of the roadway, was beyond the scope of the assignment. I think it's obvious that some internal staff at SEMA didn't have that full understanding. And in this first draft is when that disconnect between some staff and others and the clarity of the scope had not yet been finalized. That's the purpose of the review before we issue the report to the client. So that's the context of my comment.
Okay. So your view at this time was that the consideration of full illumination was not in scope because it would not be feasible to actually be done because of the EA process. Is that correct?
Essentially, yes. Similar to the comment earlier about geometry. There was no question that realignment of the freeway of the highway would be beyond scope, and the input that had been provided indicated that illumination of the mainline portions of the highway through the valley was also not feasible, and because of the approvals that had been granted through the environmental assessment processes, and therefore beyond scope. So that was clear to me at this point as I'm undertaking the review. Not sure it was clear to all the staff that had prepared the components going in, but again, that's the purpose of the review.
Okay, so let's just separate out scope, your process, from feasibility. If illumination was in scope and you completed your recommendations, wouldn't it be helpful to provide those recommendations to the city so that the city could assess feasibility?
No, I don't think so. I think it would be similar to saying, straightening the highway would be a recommendation, and that is not feasible and not possible to be achieved. It would be an improvement from a safety perspective, but it's not a reasonable recommendation to make in a report. It's not feasible to be achieved, and I think it would be irresponsible to include that in a report as a recommendation to the client. And I saw mainline illumination in the same realm.
Okay. Registrar, can you bring up CIM 8129, please? And if you can call out Mr. Malone's, oh, apologies, just before we get to this, the version of CIM 369 that we were just referring to as the native version. There is a PDF version that doesn't have the comments in the OD, but I think it would be prudent to mark the native version that does show those comments. And
Okay.
that's next exhibit 59 by my count.
Okay, thank you.
Thank you. Now turning to this, Registrar, can you call out Mr. Malone's July 26, 2 p.m. email? So you sent an email to your colleagues. We need to discuss the lighting. Is it in scope or not? As written, it's a hand grenade that will go off in the city's hands. When you say lighting here, you mean mainline lighting. Is that right?
I do, yes.
You can close that call out, please. And if you can call out the first paragraph of Mr. Appleby's response. He responds on that point. I believe it is in scope. I don't recall receiving anything from Mike that would act as an out. Apparently there is a report. Maurice, did you receive this? So is this in your evidence today an indication of a miscommunication between you and Mr. Appleby?
I think, yes, I think it's an evidence of the disconnect that we had with respect to the issue, yes. I think the report itself is a reflection of the disconnect between the two understandings.
Why are you asking your colleagues if it is in scope or not at this point if you believe that it wasn't in scope?
Frankly, I think it's a rhetorical question. In my view, it was not in scope, and the report as presented to me for review would suggest that others believe it was within scope. And so, and in fact, that's why I asked the question. I'm responding with my comments, overall comments to the report, the version 1 that had been asked to review. I had marked it up, and I provide the attachment with the email. And Mr. Appleby responds saying that he did believe it was in scope. So we clearly had a misunderstanding. It was trying to get some clarity as to where we resided on this matter.
Okay. What did you mean when you said as written, it will be a hand grenade.
Well, I think we were being contradictory in the report. There was some discussion in the report regarding the environmental constraints that existed in some areas, and then in others was recommendation for illumination on the main line. And my understanding was that based on the environmental assessment constraints, the input provided by the city to us, clarifying the scope, that mainline lighting was not within scope. And so it would be inappropriate, and therefore hand grenade is probably not the best word, but there's a contradiction there provided for the city if the report went as it had been written. And so I was of the belief that we needed to rationalize the report to make sure that it was consistent with our understanding of scope, and the content of the report reflected that correctly.
Okay, and Mr. Appleby here was looking to Mike Field to confirm the scope, not Mr. Moore, right?
Well, he mentions Mike Field in his note, correct. And from reading materials provided for my review, my understanding is that Mike Field does precisely that. He comments that the city had provided material to SEMA. I don't recall it, but he confirms essentially what's being asked here, even though apparently we can't find or don't have the material.
Okay. Would you agree that to avoid the contradictions you said that were in the report, SEMA could have provided the reference to the warrants being justified, the benefit cost analysis, those two paragraphs we just looked at, and then said the EA approvals say that this is that there's a constraint and it may not be feasible to do this. But here is the information if the city wishes to go down the road of trying to change the environmental approvals that were put in place in the 80s. Do you agree that that would have been a way to deal with any contradictions that you saw in the report?
No, in fact, I disagree completely. I think that would enhance the contradictions and not provide clarity in the report. A road safety assessment report always has constraints as to what can potentially be included. We're not revisiting the design decisions for the roadway that's under investigation. Those decisions have been completed, they've been set. Similar to the geometric alignment, determinations had been made for the overall alignment of the roadway that included fairly curvilinear alignment, a significant number of horizontal curves. We would not and did not make recommendations in that regard. And my understanding with respect to lighting, illumination was similar. There had been decisions made in the design approval and design process that determined not to include lighting. Information provided by the city was very clear with respect to that. And it would be, I think, completely inappropriate to suggest or recommend that lighting could be revisited given those constraints, because it would mean going back on original design decisions, which at this point in time I understood cannot be changed.
Okay, so just so I understand your evidence, you viewed environmental approvals to be part of the design that couldn't be changed.
They're a factor in the process leading up to the completion of design and construction of the roadway. So you can't build the roadway unless you have the environmental assessment approvals in place. And if there are constraints or rules or restrictions that are connected to that, that's something that cannot be violated in construction of the roadway. And therefore it's a fixed element in terms of what we are dealing with in our road safety review.
Thank you. Registrar, can you bring up SEMA 8124, please? So the email we were just looking at, I won't go back to it, but that was from the Friday, and now we're at July 29, the following Monday. Mr. Appleby sends an email to Mr. Nolet, one of your colleagues, and says, we're going to remove the overall lighting from the report. what happened between Friday and Monday to cause SEMA to remove overall lighting from the report, if anything?
The comments were made on the draft version of the report.
Did you speak to anyone at the city over the weekend about the issue of illumination?
No, I didn't need to. I had what I felt was appropriate input from the city as previously described.
Did you speak to Mr. Appleby over the weekend or on the Friday after the email that we just looked at?
I don't recall if there was a verbal discussion or not about the comments.
Did you tell Mr. Appleby orally or otherwise to remove the recommendation from the report?
I don't recall. Same answer as the previous question.
Okay.
I had made my comments clear in the report.
Okay. Without the information that Mr. Moore provided to you on June 6th, would SEMA have removed the illumination, the overall lighting, I'll say for this email, the illumination of the main line from its report?
I think Mr. Moore provided the confirmation, the initial indication that there were constraints were provided by the project team, Mr. Cooper and others that were present at the June 6th meeting. That's where the impetus came to speak to Mr. Moore as he was a more knowledgeable authority with respect to the element of the environmental assessment approvals. So certainly he was a component of it, and he was, in my understanding, the most knowledgeable person at the city able to answer the question, but we were directed to him by the project team. So that's why I was comfortable with the position.
Thank you. Registrar, can you bring up OD 6, page 43, paragraph 98, please? You mentioned earlier, Mr. Malone, that in your preparation, you understood that Mr. Field had confirmed. This is an email just a few days later. And in the third bullet, he says, illumination on the main line has been excluded. This decision is based on information we provided to SEMA. Apart from your call with Mr. Moore, are you aware of any other information that the city provided to SEMA that played into the decision to exclude illumination of the main line?
Can I offer or provide some input as to the timing?
Sure.
So just to be clear, the reviews of a moment ago with E00 V01 was the very initial version, draft version of the report that SEMA was reviewing. That's where I made my initial comments, and the very first version that had been prepared and the first version I had reviewed. There were several internal versions that went back and forth before completion of a version E01, which was distributed to the client. And it is my understanding that Mr. Field on this date is now reviewing or commenting with respect to the version of the report that had been sent to the city on July 29th. I just want the dates and context to be clear. So in response to your question, I don't recall any other specific material, but to me, the input from the city was perfectly clear. And
you mean the input from Mr. Moore was perfectly clear?
Mr. Moore was the person to whom we were directed by the project team, so his input was provided and he acted on behalf of the city as far as I understood.
Thank you. I am going to take you. I think you're quite right that Mr. Field is commenting on a draft that has been finalized internal in SEMA and then sent to the city between July 29th, which we were just looking at, and this email, August 2nd. I'm going to take you now to that modified version of the report that SEMA then finalizes and sends out. It is SIM 371, and I'd like the native version, please.
And if you could assist me in, if you're able to determine which SEMA version, the E00, V0, those numbers, if we're able to determine that, that would help me understand the context.
Sure, I can put that up at the, that'll be on the first page, right?
It should be, yeah. Or in the file name if you're looking at the native version.
Registrar, if you can just scroll down so that you can show the bottom part of this first page. Mr. Malone, does the file path at the bottom help you with your request around the version number? I'm not sure.
So it says draft report E00, V01. So this appears to be the same version on which I made my comments.
Right. So just for context, this is a version that Mr. Appleby has modified with track changes to reflect you and Dr. Hadiagi's comments that we were just looking at.
I don't think so, based on the file number. This would be the version on which the comments are included, but it hasn't been modified yet, because from your previous email, when I sent the comment to Mr. Appleby, I had saved it as V02.
So I understand this is actually V04, so maybe that file path is just not updated. Is that more helpful?
If that's the case, then yes, okay. It would be helpful.
Registrar, can you go to internal page 1, which is image 9? No, that's page 9. Sorry, internal page 1, which would be the 9th page of this document. No, actually, we could, oh, go ahead. Thank you. Thank you. Can you scroll down to page 3, in fact? I just wanted to show Mr. Malone that we're still dealing with track changes version. There we go. Thank you. So in this version, green, your track changes are in green. Just going to the study scope, it has review of illumination in specific areas only, i.e. not through the study area. Pardon me, I misspoke. This is Mr. Appleby's track changes are in green. Apologies. And so does that better reflect what you understood the scope to be following your conversation with Mr. Moore?
It makes sense in terms of the transition of the versions within SEMA, and consistent with the input that I understood that illumination through the valley was prohibited in conjunction with the environmental assessment approvals. Yes.
Thank you. Can you, Registrar, go to internal page 21? Thank you. can you scroll up one page, please? Thanks. That's perfect. For the illumination review, there's at the very last paragraph, you have, or pardon me, Mr. Appleby has added in the understanding that the decision not to illuminate the entire RHVP section was inextricably linked to environmental concerns and approvals. A review of full illumination was not undertaken, but restricted to spot locations. Is it accurate in your view, Mr. Malone, to say that a review of full illumination was not undertaken, given the work that your colleagues had done in respect of full illumination?
I guess technically that might be not accurate. It was not included in the report, but as we've discussed, some work had been done.
Thank you. Registrar, can you pull up CIM 811? My colleagues are reminding me that this native file that we were just looking at, CIM 371, should also be marked in its native form as an exhibit, which would be exhibit 60, please.
Okay.
Thank you. Registrar, could you pull up CIM 8118 period 0001? Thank you. And if you can call out from where it says in the white text City of Hamilton through that picture to just before where it says SEMA on the bottom. Perfect. Mr. Lynn, I'm not sure if this is helpful, but so this is a, I haven't shown you the covering email, but this is the July 29th, 2003 version that SEMA sent to the city. And is this this cover is a typical layout of SEMA reports, at least as it was in 2013, is that right?
Yes, it was.
I'm sorry, I misspoke before and said 2003, I meant 2013.
It was the cover used for this report. It's consistent with our format overall, yes.
Thank you. And so you have the client name at the top, the title of the report. It says it's in draft. And then what does B000325 represent?
That's the internal project number at SEMA of this particular assignment.
Okay. And is it typical that you just include the month and the year and not a day when a version is delivered? Where it says July 2013?
It varies. Yeah, no, I wouldn't say it's typical, but it's not unusual.
Okay. And then the E01 at the bottom, what does that represent within SEMA's numbering system, if anything?
As we've talked previously, the numbering system was an E with 2 digits following and a V with 2 digits following for internal reports. When a report was issued to a client, the V numbers were dropped. It's a way for SEMA to track versions of reports and documents that are being worked on internally and to crystallize the information, the knowledge of when a report went to a client. So E01 indicates that this is the first version of this report for project B325 that was delivered to a client. It left the building. It was an external delivery.
Thank you. Registrar, can you close that document? And I'm not going to go through that, but to your knowledge, at the commentary that we've gone through around full illumination being warranted, that was not included in the final version that went to the city. Is that right? In respect to the main line.
There were recommendations with respect to illumination on the ramps. There was no recommendation for illumination on the main line, consistent with the direction that we had been provided regarding the scope of the assignment.
Thank you. Registrar, can you bring up CIM 22409, image 9, please? So this is a calendar entry from your date book. Is that right?
Yes, it is.
Could you read that out for me, please?
Golf, Gordon McGuire, ampersand, Gary Moore.
And this is from Tuesday, August 20th, 2013.
That's the date the entry's made, yes.
Does that indicate to you that that's the date that the event occurred? That's listed here?
I'm not sure. I don't know if it occurred that day. It may have been a notation of an event on another day.
Okay. So do you recall playing golf with Gordon McGuire and Gary Moore on or about August 20th?
I don't really. I did had golfed with them on a couple of occasions, typically tournaments that are organized by professional associations or charities we would participate in. SEMA, the company would, and we would invite clients to join us.
Do you recall if this was a tournament or if this was just a trio of the three of you golfing together?
To be honest, I don't recall.
Okay. Do you recall who invited whom to this golfing outing?
Oh, I probably invited them.
Is it the first time that you had golfed with Mr. McGuire?
I don't know. I'm not sure.
Was it the first time you'd golfed with Mr. Moore?
Probably not. Probably had golfed with him maybe once before, but it's hard to say. I can't really set the dates. We participated in 5 or 6 golf tournaments at that time, 5 or 6 golf tournaments a year. It would invite various clients if they wanted to be part of our foursome.
Okay. Sitting here today, can you confirm if this was part of a golf tournament or was just a private golf outing?
I don't recall. I don't know whether this was the date of the golf or this was the notation of the invitation, the communication with them, or even just my note to potentially contact them to go golfing. I do recall golfing with them on at least one occasion, 2 of them together, but I'm not sure exactly which event this relates to.
Okay. Do you recall if you went golfing with them outside of a tournament, just 3 players going golfing together?
Could have at one point in time, yes.
Did you talk about business during this golf trip?
Probably, yeah.
Did Mr. Moore discuss the 2013 SEMA report with you?
I could not recall.
What about Mr. McGuire?
Could not recall. I doubt it because at that time, Mr. McGuire would not have been as closely connected to this particular subject matter.
Do you recall if any of the conversations over golf with Mr. McGuire and Mr. Moore resulted in changes to the 2013 SEMA report from this point forward?
Sorry, with respect to this date, this entry?
Yeah. Do you recall if any of the conversations that you had over golf with Mr. McGuire or Mr. Moore resulted in changes to the 2013 SEMA report?
I don't recall, but I certainly doubt it. This is dated August the 20th. The report had been just sent on July the 29th.
Okay, and there's subsequent drafts that go back and forth. And so my question is whether in any of those subsequent drafts, whether any of the conversations that you had with Mr. Moore and Mr. McGuire resulted in any changes to the 2013 SEMA report.
I don't recall any subsequent conversations with Mr. Moore nor Mr. McGuire regarding the 2013 report. The conversation with Mr. Moore that I do recall is the June 6th conversation. If the note says golf, I'm sure we golfed at some point in time, but I have no recollection of what the conversation may have been as we were proceeding through the course.
Okay, thank you. Registrar, can you pull up OD 6, page 45, paragraph 105, please? Thank you. So on August 23rd, Mr. Appleby and Mr. Cooper have a discussion about the now second draft that's gone to, or that is going to the city in this email. Do you recall whether you reviewed a second draft of the SEMA report before it went back to the city?
I'm not sure. I'd have to look at the document itself, the Word document, and validate whether there were changes. I commented on E00V01 as we've discussed. I'd have to check the actual document.
Okay. Registrar, can you bring up OD6, page 49, paragraph 119, please? In September, this is an internal email among SEMA colleagues advising that Mr. Appleby had completed updates to the draft report based on review by the city and as well as our internal discussions. Do you recall being involved in the internal discussions about the city's comments on the draft that SEMA had sent to the city?
I don't have a clear recollection of it. It wouldn't surprise me if I was, but I would have to check the version to see if I made any comments in the document.
Okay. Did Mr. Moore contact you to discuss the draft report after SEMA sent it to the city?
Not to my recollection, no.
Did you ever come to learn of his view, what his views were, if any, on the draft report?
Through the materials I've reviewed for this inquiry, yes.
And in advance of 2019?
No.
Oh, pardon me, I misspoke. Before 2019, had you learned of his views before preparing for the inquiry?
I never received anything from Mr. Moore.
Okay.
What I'm not sure is if any of his views were reflected in input provided by the project team.
Registrar, can you go to OD6, page 61, paragraph 155, please? So in October, Mr. Appleby sent an updated version of the report with changes in the wording, tables, etc. Were you involved in, do you have a recollection of being involved in the changes at this point?
Similar answer. I don't have a clear recollection of being involved. It wouldn't surprise me that I would have seen these versions as they go out. Either Dr. Heidi Aggie or myself would review the E01, 02, or whatever that was delivered to the client. And so it would be either him or myself who would have undertaken a review.
Okay.
Again, I'd have to double check to see if I was the reviewer. It's also possible both of us reviewed.
Okay. Did you have any involvement in the preparation of the report by city staff prepared for the Public Works Committee in respect of the 2013 SEMA report?
Not directly. I recall that the city, there was back and forth with the city about the format of tables in our report, and they were wanting or going to use a similar format, or perhaps vice versa. They had a format of a table that they wanted to use, and were suggesting that our report could follow a similar format. But no, absolutely no direct input on preparation of the city report. We never have input on preparation of the reports by the municipality to council.
Thank you, Registrar. Can you pull up OD6, page 69, paragraph 175, please? So here, the final staff report, so this is the staff report, not your report, was finalized on October 25, 2013. And if you can close that, registrar, and open up paragraph and call out paragraph 177, please. So a few days later, these are emails internal to the city with Mr. Lupton, Mr. White, and Mr. Ferguson in respect of a conversation with Geary. Mr. Lupton says in the third line, I'm not asking to change opinions, but to soften and stage the report similar to what we have done with our info report, i.e. do this first and measure results, etc. Please sit down with SEMA and make this happen. You can close that call out. Did you ever discuss modifying the SEMA report to reflect the report that staff were preparing, either with Mr. Ferguson or with Mr. Cooper?
I recall there was some discussion around timing of some of the recommendations, and I think illumination was part of that. I believe the city, there was some discussion about whether it should be a short-term or a medium-term recommendation. And I know it went back and forth to some extent. When SEMA makes a recommendation, we try to give reasonable timelines as to when something can or should be done. But we don't have direct control over those decisions, determinations. And so the client ultimately has that decision to make as to whether they'll accept recommendations and implement or not, and the timeline for implementation or not. So I do recall there was some discussion about elements of the report, and I believe illumination was part of those with respect to timing.
In your view, is it appropriate for a client to ask you to soften and stage a report if that doesn't involve changing SEMA's conclusions?
Well, to be clear, I never received, to the best of my knowledge, nobody at SEMA received any direction to soften and stage the report. The email referenced in paragraph 177 is SEMA was not included. It's not uncommon for clients to offer input with respect to the content of reports. And I do recall that there was some expansion of clarity relating to various issues, including illumination and the clarification of the constraints that existed with respect to environmental approvals regarding mainline lighting. So I never received any direction to soften and stage, and I would not agree to soften and stage, in that explicit quote, but certainly would accept input from clients. That's why we provide them with versions of a report, and we're prepared to listen to what their input would be. But no, we don't change our recommendations based on client input. We will listen to their concerns and comments and react appropriately.
Thank you. So in terms of staging, Mr. Lupton says, can we stage the report similar to what we have done in our info report, i.e. do this first and measure results. So I'm going to just provide a bit of extra facts there. If a client asked you to change the timing of your recommendations, i.e. from short term to medium term or medium term to long term, to reflect what Mr. Lupton says here, do some things, measure their results, and then do other things. Would you have a concern with that kind of request from a client?
Well, I don't see it as a request from a client. I see it as a client's explanation or description of how they are potentially going to respond to the inputs provided in the report. So the client obviously has the choice to decide how they may wish to implement. What does come to us from clients fairly regularly is the reality that as the consultant, we're not fully familiar and certainly not in control of their budgeting processes. And so where SEMA may identify something with a timeline for implementation, we are not necessarily fully versed on the budgetary and timeline constraints that exist within the city. So for example, if an item can be achieved using an operating budget, that typically would mean it can be done fairly quickly. But if something is a larger expense and would be considered a capital expenditure, that may require a significantly more detailed process to obtain the funds and complete the work. So SEMA's input regarding timing, to be crude about it, may be ignorant of the capability of the client to achieve a particular timeline. So I think the client informing the consultant of the realities of budgetary and time constraint to achieve a certain outcome is reasonable to provide, and appropriate adjustments would potentially be made. I don't think it's appropriate to, SEMA does not direct the municipality to do work. We provide options and suggestions for them to do, and it's their decision if they will accept them and how they will undertake them.
Okay, so you said it's appropriate for a client to inform a consultant about the realities of budgetary and time constraints. And then you said appropriate adjustments would potentially be made. You mean SEMA would then adjust its report to reflect the budgetary and time constraints that the client has provided to you?
Potentially, if an item had been listed in a time frame for which budgeting cannot be achieved because it required capital budgeting, for example, that needs to be programmed at some timeline duration to get there, I think we would recognize that reality and incorporate that into the report, because I think it's in fact, it doesn't change the recommendation at all. It simply puts things in the appropriate context. Again, we're undertaking a safety review here. We're not providing design for the highway. We're offering suggestions of various opportunities for safety improvement that could be achieved by or could be undertaken by the client. They will review those and they will provide some determination as to whether they'll accept them and or what their timeline will be for installation. We provide timelines within our report, partly in recognition that some things are relatively minor, it can be done quickly, and also that others will take more time and need to be integrated. And it's an implementation that where one item potentially can be done before another item is also potentially the situation.
Thank you. I'm going to turn now to OD 6, page 80 and 81, please. And if you can bring up, well, we'll just leave it like this just so you can see it. In paragraph 207, Mr. Cooper responded to a message from Mr. Appleby to go ahead with wording changes and to make final copies. And Mr. Appleby asked, do you want the date to be changed? So this is in December. Actually, pardon me. You know what? I'm going to come back to this. Can you close this down and open up HAM 41871, please? Before we go to December, I just want to show you this. So this is version, it's hard to read from here, but it's E05 and it's October 2013. And if you can close it down, it doesn't say draft on it anymore like the earlier one. What does that mean in terms of whether this draft is final or not?
Well, any version without the any report numbered without the V numbers after the E numbers indicates it's been delivered to the client. My understanding at this stage we're at here is that this was the last edition that was issued to the client E05.
Okay, so do you, when you deliver SEMA's final version, the version that SEMA views to be final, do you call it final, or do you just take off the draft note on the cover page?
Well, it depends on the project. Some projects never go out with draft and never go out with final. It varies from project to project. Some clients like a version of the report that says final. Other clients don't care. Our record reflects the various editions that have been issued, and the E05 is my knowledge of this project, it's the last version that went to them. So by definition, it was the final version.
Thank you. Registrar, can you go to image 5, please? So this is just in the executive summary, but just to see the overall study area countermeasures in a chart. You have a number of countermeasures: friction testing, PMPR. What's PMPR? Pardon me, PRPM.
Permanent road pavement markers.
So those are markers.
Cat size would be the colloquial.
Cat size. And then you have some other markings: slippery when wet signs, enforcement of travel speeds, trailblazer signage, removing other signs, exit signs. And in the right-hand side of this column, you have ST and MT. Is that short-term and medium-term?
That was the intention, yes.
Okay, and so that's for the overall study area. And then table 2, which is actually a few pages, starts with the road segment countermeasures. So that's on the particular segments that we talked about, and there's additional countermeasures there. Is that right?
Yes.
Registrar, can you go to the next image, please? Thank you. And so you have the list under the countermeasure. You have also signage, some maintenance, those sorts of things. And then if you can go down, Registrar, to the next image. Then you have a table that has the ramp countermeasures. So you've separated out overall study, segment by segment, and then the ramps. Is that right?
Yes.
Having delivered E05, that version to the city, did SEMA have any further obligation to the city to finalize this project?
I'm not sure I understand the question, but no, delivery of the final report is the completion of our assignment.
Did SEMA have any responsibility to take any steps to follow up as to whether the city had completed the recommended countermeasures?
Can you define responsibilities?
Did you have any continuing project in which you were project managing the implementation of the countermeasures?
No.
Thank you. Now I'm going to go to OD6, page 80 and 81. So here in paragraph 207, there's discussion with Mr. Cooper and Mr. Appleby about this is in December. So we were just looking in October. This is in December, back and forth to go ahead and make wording changes and to provide final copies. And you'll see in paragraph 208, Mr. Appleby then sent Mr. Cooper a PDF of what he described as the updated report. And 209 sets out the revised information. You see that?
I do.
Were you aware of further discussions between the city and Mr. Appleby in December 2013?
I don't recall precisely. I suspect I would have been, but I don't remember.
That you don't recall either way?
Well, I don't recall a specific discussion, no.
Okay. Do you recall being aware that Mr. Appleby was providing revisions to the report in December 2013?
Yeah, I think Mr. Appleby sent draft pieces or selection of parts of the report to Mr. Cooper with the proposed changes prior to this December 9th date.
That's right. I'm asking about your awareness of that back and forth.
I'd have to check the email thread to see if I was included or not.
Okay. I'm going to move on. I'm moving on now a couple of years to 2015. Registrar, can you bring up HAM 24096, please? Thank you. And can you call out the email from Martin White at 9:23? It's the second email. Thank you. So this is from Martin White to John Mader. You are not copied on this email. John Mader, pardon me, Martin White describes a conversation, or at least he references your name. He says, Malone even told me he is charging us a bit extra due to Gary. He wants to be sure his recommendations are totally defensible. He asked me what he should say when Gary calls him. I told SEMA to do the best analysis they can and give us the best technical options and to not worry about what Gary says to them. Do you recall having a conversation like this with Mr. White?
I don't know.
You don't recall having any conversation in which you told Mr. White that SEMA was charging the city a bit extra because of Gary?
We would not charge the city a bit extra. The rates are set in accordance with the retainer process, roster process. There's no ability to charge extra. We were engaged in an assignment relating to crossover collisions on the link. So certainly had been in communication with Mr. White regarding that assignment. But I don't recall this, and I don't. It's not something that was ever relayed to me, and I don't recall ever speaking to Mr. White in this manner.
Would the potential for Mr. Moore's involvement in a project affect the cost in any way from SEMA's perspective?
Not from the perspective that, no, not from Siemens. I mean, our work is traffic safety reviews, and Mr. Moore potentially could provide input and information as he did on the 2013 report based on his knowledge of the link and the Red Hill projects. But no, he wouldn't impact cost at all. It would be factored in as one of the information collection. Any communication with him or his office would be factored into the overall cost of the assignment.
Did you find Mr. Moore difficult to work with?
I never really worked with Mr. Moore, so he was never a client of SEMA's. So I can't comment on whether he was difficult to work with or not. He did provide information in the 2013 report. He responded to my request as I had been directed to speak to him, and he gave clear input that was useful and helpful.
How would you describe Mr. Moore's communication style when you did have interactions with him?
Straightforward.
Blunt?
That could be a matter of opinion, but I would say straightforward.
Did Mr. Moore's communication style ever interfere with the work that you were doing?
No, not at all.
Did you see Mr. Moore socially?
Sorry?
Did you see Mr. Moore socially?
Other than the golf tournament events I described previously, no.
You had no other
Sorry,
social relationship with him?
sorry, I should correct that. I would also had met him numerous times at various conventions, professional association conventions, but no personal relationship.
Thank you. I'm going to turn now to the 2015 SEMA report. You can close that, Registrar. Thank you. So you mentioned just a moment ago that that SEMA was doing some work in respect of a safety review on in respect of the link, and that was in 2014, 2015. Is that right?
I don't remember the precise dates. I know we were engaged in that assignment. It was underway at the time we got the request to do what's being described in this inquiry as the 2015 report.
Thank you. Okay. So in May 5, 2015, a crossover collision on the Red Hill resulted in the deaths of 2 young women. Do you remember hearing about that crossover collision?
I was aware of it. I think I heard it in the news or in the press.
Are you a Hamiltonian yourself?
No, I live in Grimsby, Ontario.
Registrar, can you bring up OD 7, page 9, paragraph 24, please?
Sorry, Council, do you mind just repeating the page?
Sure, OD 7, page 9, paragraph 24. Thank you. So on May 11th, there's an email in the OD that Mr. Ferguson emailed you about the possibility of SEMA conducting a review on the Red Hill for possible barriers. He's just asking for a cost. I'm going to turn up now some notes of yours. So you can close that, Registrar, and if you can open SIM 22418. Registrar, would you like me to repeat that? SIM 22418.
Sorry, Council, is it under a different doc ID maybe?
Maybe. Why don't we try 22410? And if you could go to image 6, please. So this is not your notebooks that we've been looking at where the date's in the corner, but is this, can you identify this as your handwriting in another notebook?
I switched notebooks style.
Okay.
So this is my notebook and the date is on the top of the page.
All right, and it says, Dave Ferguson, can you read the rest?
Dave Ferguson, detailed analysis of RHBP as link new bullet, also through in lighting, and a new bullet, May 21st meeting.
Yeah, I read that as also throw in lighting. Is that? But
Could be.
okay. So is it fair to say from this note on the 13th, you had a discussion with David Ferguson about a detailed analysis following that email that he sent you on the 11th?
Yes, I'm assuming there was a discussion. The entry would likely have been a conversation with Mr. Ferguson.
Okay. Registrar, can you bring up OD7, page 12, paragraph 35? And can you bring that up with page 13 as well? Thanks. So you'll see at the bottom. Yeah, you can call that out, Registrar. Thank you. And that's fine. You don't, that's fine. We'll just start with this. So this is the first part of an email that you send to members of your team, summarizing a discussion that you'd had earlier that day. I spoke to Dave Ferguson on this matter today. Your last sentence, the review will be for the RHBP and would include the areas towards the escarpment where the lighting is absent, essentially a repeat of the previous work. Just stopping there. The previous work is the 2013 report.
Yes, the previous work started at the Dartnell interchange, which is the beginning of the Red Hill Valley Parkway. And this review I understood to be the entire yeah, this review would include the entire permit. There was some confusion in the beginning as to what this assignment was going to be, whether it was going to begin where the 2013 assignment ended at Green Hill and proceed to the north, or would go back all the way to Dartnell and cover the entire Red Hill. I don't recall at this moment whether that was clarified yet. I seem to recall there was some input from Mr. Warren that confirmed that.
Okay, but at the end of the day, the 2015 SEMA project was in fact for the entirety of the Red Hill. Is that right?
At the end of the day, it was, yes, it was from Dart all the way through to the QEW.
Okay, so just I'm picking up where I had stopped there with a recognition that the answer regarding lighting is not simply no as it was previously. What did you mean when you wrote the answer regarding lighting was not simply no as it was previously?
I think I was reflecting the input from Mr. Ferguson that what had been clear in the previous report and that the scope of the assignment had restricted illumination to the ramps and not to the main line. In this case, that we were being directed to ignore that.
So you understand the scope, you understood that the scope for this project would include assessment of illumination on the main line.
That's what I believe it says in the note, yes.
Okay. Registrar, can you go to OD7, paragraph 17, pardon me, page 17, paragraph 43? Thank you. So following week or so, Mr. Ferguson copied two of his colleagues or sent an email to two of his colleagues and copied you and outlined the items that needed to be reviewed, some type of barrier. Is there a need for lighting and expected costs, analysis of types of collisions that are occurring? And this is really just a timing thing that reporting to be completed in September. You responded attaching a preliminary work plan. I'm going to bring that up. Registrar, it's HAM 4660. Registrar, can you just scroll down to the next image? And so you'll see there's a work plan, and this work plan to me looks very much like the work plan that we went through in the request for quotation. Registrar, if you can just go down to the next page. So you see it's a series of tasks, including collision review and other tasks. Is that fair that this is the way that CMEC organizes its work plans?
For significant safety reviews, this would be consistent with what we provide, regardless of who the client was.
Did you draft this document yourself?
Probably not the original draft. I may have had input to it.
Would you have reviewed it before it went out?
If I've signed it, I would have reviewed it, yes.
Okay. Do you recall, was this an assignment from the city roster?
My recollection is yes.
Do you recall receiving any feedback on your interpretation of the city's requirements? That is the work plan that's set out here.
Yeah, I think as you showed on the previous page, there was the physical limits of the beginning and end of the assignment were inconsistent with what the city was wanting. So there was some back and forth that clarified that. The scope in this document, yeah, that picture there shows that it was to begin essentially where the 2013 study ended and proceed north up to the Barton Street rail bridge, the rail bridge just north of Barton Street. And there was clarification that followed the submission of the proposal to bring it all the way up to where the link study was ending, instead of stopping where the 2013 Red Hill study had ended, if that makes sense.
Okay. And apart from that feedback about the boundaries of the study area, did you receive any other feedback from the city?
I'd have to go back and check the notes. I don't believe there was a second submission. The clarification may have come just through emails.
Okay. Registrar, can you go to OD 7, page 25, paragraph 67, please? Thank you. So we just move forward to July of 2015. There's a back and forth between you and Mr. Warren, who's at the city. And you said, we're anxious to proceed with the review, but we've not received a green light. Do you recall there being some delay in starting this project and therefore feeling like there was some pressure around timelines?
Well, there were definitely pressures around timelines. I recall that, but we need approval from the client to do an assignment. We prefer that approval come in the form of a purchase order because typically the client prefers that as well. Sometimes, work, if there's a necessity to fast track, work will initiate on the handshake agreement that the approval is coming.
Register, can you cancel that call out and call out 69, please? Paragraph 69 on the next image. So this is also in July. Mr. Warren sends the purchase order, asked you to get started, and says in the first bullet, will you still be able to meet the proposed draft submission date of July 13th? And this was on July 8th. Registrar, if you can close that call out and call out 71. And you said July 13th is going to be problematic. sort of close that out, close that. Thank you. You can go back, Registrar, to 67, just while you're doing that. This was going to be a significant project and you were going to need more than a week to complete it. Is that fair to say?
Well, we didn't even have data, so it was not going to be possible. I was trying to be polite in response to Mr. Warren.
Just turning back to this, the third paragraph, you say to Mr. Warren, it was also suggested to me that we speak with the Public Works Road Maintenance staff as they may have some insight about collision history that has involved infrastructure, guardrail damages that may also assist in the review. And you say most of what they can provide will be mirrored in the collision reports, but we'd be pleased to meet with them. It says, it was suggested to me. Who suggested that to you?
I'm not exactly sure. It could have been internal staff. Information from anecdotal information relating to collisions can potentially be useful. And I know internally, some people had commented that they had seen damage to guide rail along the Parkway. I drove the road regularly, others did as well. And I think they thought there might be some information to be gained from the awareness that the city would likely have had about damage to guide rails. It would be anecdotal, but it would possibly be useful for understanding what's going on at the location.
Okay. Registrar, can you close out this call out? Go to the next image. Pardon me, the next image after that, and call out paragraph 72. Just following on this, Betty Matthews Malone emailed you and Sam Caposnago, District Supervisor Roads, under the subject line Red Hill Safety Review. And this is an email that Ms. Matthews Malone is sending primarily to her colleague, introducing you as a consultant that will be undertaking a safety review. Is this the introduction to the road maintenance staff that you had suggested to Mr. Warren?
I think the order might be different. I think what happened is we probably spoke to Mr. Warren about the potential benefit of speaking to the maintenance staff. And as you know, Ms. Matthews Malone is my wife. We potentially had a discussion about it, and she may have said, "Oh, I'll have Sam call you. I'll put you in touch with Sam," shortcutting the connection to the operations maintenance staff.
Thank you. And Ms. Matthews Malone, she at the time worked for the city, right?
She did.
Do you know what her role was at this time?
I believe her title was Director of Maintenance and Operations, but you have to confirm with her.
Okay. But in essence, she was the director responsible for the road maintenance crews?
She was the director responsible for road maintenance and operations, yes.
Apart from this email where she introduces you to the district supervisor, did Ms. Matthews Malone play any role in SEMA's projects for the 2013 or 2015 SEMA reports?
No, not at all. She wasn't employed at the city during the time of the 2013 reports. She had started her position, I think, in 2014. So she was there at the time of the 2015 report, but that department didn't have anything to do with our reports. So other than this communication, which was an introduction to the appropriate staff, which I relayed to my staff at SEMA, there was no connection or discussion.
Was she instructing client for any aspect of the 2015 report?
No, not to my knowledge.
Did you have any discussions with her about the work that SEMA was doing in the 2015 SEMA report?
I'm sure we talked about over the dinner table the the fatality involving the collision involving the fatality of the two girls was a high-profile event. It was very public in the newspaper, so I'm sure that came up in conversation. And I no doubt relayed that we had been engaged to undertake a review following that incident occurrence.
Other than that, any other discussions with her about the review as it was proceeding?
No, we typically didn't discuss work at the dinner table.
Was SEMA aware, that is your partners at SEMA, were they aware of your spousal relationship with Ms. Matthews-Malone?
Yes, fully. I had declared a conflict of interest statement and filed that with our company, which is in accordance with our internal policies. And I know my wife had done the same thing at the city as well.
And SEMA was aware that Ms. Matthews-Malone had done the same thing at the city?
Yes,
SEMA, not just you, but your partners?
Well, they were not provided with her letter, but I had made them aware that she had informed them of the potential conflict of interest, and I had done the same thing.
And had SEMA assessed if there was any potential conflict in you doing work for the city, given your wife's position at the city?
I asked them to review that, and they confirmed for me that there was no conflict of interest in their assessment. SEMA had a very comprehensive process for confirming conflicts of interest and a process to document potential conflicts of interest, which I had done immediately upon her starting her position at the city. And I updated that when her position changed in 2018, I believe it was. She changed job titles. And so we reviewed it regularly, and I checked with my supervisor at SEMA specifically with respect to it. It was always something that we wanted to make sure was properly covered.
Thank you. Registry, can you close this call out and open up OD 7, page 35, paragraph 104, please? And if you can call it, thank you. So we're in August of 2015 at this point. We just went through in July, you got the PO, so SEMA had started the work on the 2015 safety review.
Yes, at this point we were underway with the assignment.
Okay. So this is a note that you made in your notebook. It's a excerpt from it, but it is from August 5, 2015. Can you can you read out what's written here?
I can, but there's another note. There's another note on August the 6th.
Yes.
I know that some of what is included in this note, which is dated August the 5th, was in fact from a conversation that occurred on August the 6th. So I think it's important to have the two of them side by side because they overlap.
Fantastic. Let's do that. Hopefully you'll still be able to read it if we do two call outs.
Should be okay.
Registrar, can you do a call out for the August 5 note that you just had called out? And then can you also call out the note, which is on the next image, right at the top of the page? Yeah. Or Mr. Malone, if you can read it at this font, we don't have to do the call outs. It's up to you.
It was fine as you had it before the call outs.
Okay, you can cancel the call out, Registrar. Thank you. So maybe I'll just ask some questions just given the context that you've just provided. So there's these two notes, August 5 and August 6. Do you think that the August 5 notebook entry contains notations from an August 5 meeting only?
No, I know it contains a hybrid of inputs from an August 5th meeting, which occurred internal at SEMA, and the 6th discussion, which occurred with Mr. Moore.
Okay.
Portions of what is shown on the August 5th image are from the conversation with Mr. Moore, which occurred on the next day, August the 6th.
Okay, so why don't we look at the August 6th note first? Actually, no, let's do it this way. Can you identify what notes are from your internal meeting with SEMA on August 5.
Yeah, I believe it's the top portion only. So the yellow highlighter, Red Hill Parkway B558, that's our project number. And this is, my recollection was this was internal discussions that we were having at SEMA regarding aspects of the project. Asphalt has an asterisk or a star. Friction testing, asphalt was listed. Drainage with respect to that's centerline median, and speed study, and police ball bank. Jason, that is my recollection was what was in the August 5th meeting, and the question mark Gary Moore was just that, my notation to ask a question of Gary Moore regarding friction testing.
Okay, thank you. So at this time on August 5, what, if any, tentative conclusions had SEMA reached regarding recommendations for friction testing?
Well, at this point, we had undertaken a fairly comprehensive analysis of the collision history for the roadway. We had received updated collision information for the portion of the roadway that had been covered in the 2013 study. And so we redid the collision analysis for the entire length of the roadway from the Dartnell interchange all the way through to the Queen Elizabeth Highway interchange. We had found a number of things. One of them was that there was a significant number of wet road collisions, and some of those were specific to certain areas. And the other was that some of the speed information, which had also been reviewed, was relatively high. So a portion of that was consistent with what had been identified in the 2013 report, because we were going over that Dartmouth to Greenhill area again, albeit with updated information. And another portion was brand new. We had never looked at anything north of Greenhill before. So we had one set of findings which was consistent with what had been found in 2013, potentially that a preponderance of wet road crashes might be something that would be indicative of a need for friction testing to understand the asphalt performance. And so consistent with 2013, and the same finding was coming forward in the new data in the areas to the north of Greenhill. So it was partly repetition, if you like, update of the 2013 area, and partly brand new information based on new collision data for new sections of the highway that had not been reviewed prior to this time.
Thank you. And so given that work that you had done and the analysis you were conducting for the entirety of the Red Hill, what conclusions had you reached about, particularly about doing friction testing on any aspect of the Red Hill?
Well, my recollection from the meeting was that there was our internal discussion was essentially a question mark. We thought we had suggested that friction testing could be done on the portion of the roadway to the south of Greenhill, what was in the 2013 report. Friction testing was a recommendation included in that report. And we had never been made aware as to whether or not that friction testing had been completed. So we didn't know any results from that, or what, if any, action the city had taken regarding friction improvement on the highway and or friction testing in general. And we were finding that new portions of the roadway being investigated were also indicative of the potential need for assessment of the friction condition of the road surface, given the preponderance of wet road collisions. So we had no friction data. We had nothing to go on, and to our best of our knowledge, city had not done any friction data. So the question was on the SEMA table as to, what's the status of friction testing, and therefore the question mark Gary Moore was find out. He would have been the person who, again, with his intimate knowledge of the Red Hill and the link, he would be the person who would have been responsible for undertaking it, as far as I understood.
Okay. And before considering contacting Gary Moore, did you ask Mr. Warren, Mr. Cooper, or Mr. Ferguson for friction testing results from the recommendation in 2013?
Not to my recollection. This internal SEMA discussion occurred on August the 5th. To me, the most expedient route would have been to go to Mr. Moore. He was the person with the most knowledge of the Red Hill in particular, and it made the most sense to speak to him. Jason Warren was relatively new to the city. He was not there when the roadway was constructed. He didn't have any real knowledge of it, so he wouldn't have been the person. So Gary Moore was the proper source, and as the notes indicate, I spoke to him the next day.
Okay, and can you describe, with reference to these notes, your discussion with Mr. Moore on August 6th?
So I called Mr. Moore on August the 6th, the following day. The image on the right-hand side, page 36, is my beginning of my notes. Gary Moore, that's 4867 was his extension, telephone extension, and Hamilton Red Hill. And then my recollection is we had a discussion, a conversation about friction testing, and Mr. Moore provided a bunch of information regarding the nature of the roadway. You see notes relating to perpetual pavement, resilience on top course, richer mixed bottom, SMA asphalt, stone mastic asphalt was the clarification of what that was. Skid resistance, MTO did skid resistance test. And then I also recall that I wrote notes on the bottom of the previous page, which was the August 5th entry, continuing to expand on the comments from Mr. Moore. High skid resistance SMA, higher SMA, special aggregate, SMA, stone mastic asphalt, gap graded, quieter drains, not a lot of fines, 260 thick, which would refer to the thickness of the overall depth of pavement, 260 millimeters. And these were notes that I had marked down in conjunction with the conversation that we had on August the 6th.
In terms of stone mastic asphalt, was that term a new term for you arising out of this conversation with Mr. Moore?
It was, yes.
What information, if any, did Mr. Moore convey to you about the skid resistance of SMA?
Well, the note I had scribbled was there's high skid resistance SMA, higher SMA on the left side image. So I think that's my notation that he was describing SMA asphalt as having higher skid resistance.
Higher skid resistance than what comparator?
I don't believe he provided a comparator. I'm assuming he meant with regular asphalt pavement.
Okay. And you referenced the note that said MTO did skid resist test. Did he?
My notation of his conversation, his words.
So those were his, he was conveying that information to you?
That's my recollection, yes.
Did he tell you when MTO had conducted friction testing during this call?
Not at this time. There was subsequent information that provided clarity.
Okay. And did he tell you that he was going to provide you with information during this call?
You know, I don't really remember that portion of the conversation, but I'm sure that's exactly what happened because the follow-up note indicates, here's the information essentially, as per our discussion.
Okay. But sitting here today, you can't remember whether he said, oh, I'm going to provide you with some information.
I don't remember that level of detail of the conversation.
Okay. And then from that, I assume you also can't remember how he characterized the information he was going to send to you. Like how he identified what he was going to send to you.
Well, other than the note here that MTO did skid resist test.
Okay. In the telephone call, do you recall whether or not Mr. Moore mentioned Tradewind or Golder Associates?
I have no recollection of that. I was calling Gary Moore because SEMA as noted in the August 5th note, was contemplating the potential need for friction testing on portions of the highway north of Green Hill. And I know that our 2013 report had recommended friction testing on portions of the Red Hill south of Green Hill. And so I was highlighting that to him because I didn't know what had happened with the original recommendations, and I was trying to get an update. And so his input about did MTO did skid resistance was part of his response with respect to the question.
Okay. So recognizing you don't have a perfect recollection, is it your recollection today that Mr. Moore, in response to your question about whether the SEMA recommendation in 2013 had been implemented to do friction testing, that Mr. Moore's response was MTO did friction testing? Or were those two divorced parts of the discussion?
Yeah, I think it was probably the latter. I don't think there was a direct connection between the recommendation in the 2013 report and an answer being that the MTO did skid testing. I think they were separate elements, and he was telling me about the pavement. He was telling me about the material used, the SMA, and he was telling me that MTO did skid resistance, albeit in this time without any context of dates and times.
Okay, and what impression were you left with coming out of that call about whether the city had completed friction testing in response to SEMA's recommendations?
My impression at the time was that the city had not done friction testing in conjunction with the 2013 recommendation.
Did you convey to Mr. Moore your preliminary findings in the collision review?
I'm not sure in the conversation at what level of detail. I'm pretty sure I relayed to him that we were contemplating incorporating friction testing, a recommendation for friction testing in the 2015 report. And I highlighted to him that we had done so in the 2013 report, which I would have understood he already knew, but I was reminding him of that.
During that call, did Mr. Moore tell you his view on whether or not the Red Hill had good friction levels?
I think the notation on the August 5th, the page that says high skid resistance SMA, higher SMA, is an indication of what he believed was present on the road.
Thank you. Commissioner, I see that it is 11:34. I'm going to continue a related topic, but I'm going to close out this call out. Would now be an appropriate time for a morning break?
Sorry, I just had to unmute there. Yes, why don't we take our morning break now? We'll return in 15 minutes. That'll take us to 10:02.
Thank you.
Okay.
Mr. Malone, just before the break, we were talking about a call that you had with Mr. Moore, and you said he sent you some documents after that call. Registrar, can you turn up SIM 10018?
Sorry, apologies, council. Just having a issue with on queue.
Okay.
Sorry, if you could just repeat the doc ID for me.
SIM 10018. Thank you. Mr. Malone, is this the document that you were, or the information that you were referring to that Mr. Moore sent you after your call?
Yes.
Okay, so at the top is an email from Mr. Moore to you on August 7. And he says, Brian, here is the Red Hill friction testing summary, not for republication, exclamation mark, thanks. And then he has forwarded in an email from Ludimir Urzeski on January 24th, 2014. And then there are also 3 additional documents that are attached. I'm going to just show you those 3 additional documents just to make sure that we're all looking at the same thing. Registrar, can you bring up SIM 10018.001? This is a multi-page paper addressing early age low friction problem in stone mastic asphalt pavement in Ontario by a pavement engineer at MTO. Do you remember receiving this from Mr. Moore?
I know it was attached to the email that he sent, yes.
Prior to receiving this paper, were you aware of early age low friction problems in stone mastic asphalt?
No.
Did you review this paper when you received it from Mr. Moore?
I may have reviewed it briefly, but not comprehensively at all.
Okay. And then if we can go back to SIM 10018, please. So in the body of the email from that was forwarded to you, it says the surface asphalt on the RHVP is stone mastic asphalt. Immediately following construction in 2007, the Ministry of Transport conducted friction testing on both southbound lanes, and then there's a table. There's also references in 2013 to friction numbers measured on the RHVP in both directions by Tradewind Scientific using a grip tester. Just stopping there, did you at the time, were you familiar with the company Tradewind Scientific?
No.
Were you familiar with the methods by which friction testing was conducted? That is using a grip tester or other devices.
I knew there are a variety of methods to measure friction. I wasn't necessarily familiar with the grip tester method more intimately than any others.
Okay. And there's also this reference to the paper that we just looked at. Going now to just back up to the first paragraph of that paragraph, says the complete testing results are attached. Registrar, if you could go to SIM 10018.0002. Do you remember receiving and reviewing these?
The version I saw had color in it, but
That might have been right. That might just be a photocopying or a transmission error in the inquiries process.
I don't recall this black and white document. If it's the same as the one that had color and I think a green banner, then I would have opened, I did open the attachment.
I am just going to see if I can assist with that particular issue.
Sorry, Council, I can open the native of it.
That would be great. Thank you. So I think that this would be MTO 2228.
I have it as this document as well, if that helps.
If you can pull up the native that you have and reference the doc ID, please.
Okay, so this is CIM 10018.2.
Thank you. Is this, Mr. Malone, is this the format that you recall reviewing?
That's my recollection. It was an Excel spreadsheet and the colors are more familiar.
Great. And for just for the commissioner's notes, these are documents that have previously been referred to, and they are also MTO 2228 and 2229. But we're using this doc ID because these are the ones that were sent to Mr. Malone. So looking at this, had you seen spreadsheets like this that set out friction testing?
No, not to my recollection.
Registrar, can you bring up the other native file, which would be 10018.0003? Thank you. So this would be the other of the two attachments, the Excel attachments that you received from Mr. Moore. Is that right?
I believe so, yes.
Okay. Registrar, can you click on the bottom where it says chart? Both of the Excel spreadsheets have a chart like this. Do you remember if you looked at the charts as well?
I don't recall precisely. I probably did, yes.
Okay. Registrar, you can close that. Actually, sorry, if you can bring up the email, which is 10018. CIM 10018. Perfect. Were you able to interpret and understand the data in the email that Mr. Moore forwarded to you?
I didn't attempt to.
Based on your review of this message, who did you think conducted friction testing in 2007?
Well, it was clear that according to the input from Gary and the notes from the August 6th, that the MTO had conducted the friction testing, and I understood this note to verify that, and this was MTO information, not City of Hamilton information.
Based on your review of the message that Mr. Moore forwarded to you, who did you think conducted friction testing in 2013?
I wasn't sure, so I asked questions to Mr. Moore, and there are subsequent emails to which he provided a response.
Do you recall having conversations with having a conversation with Mr. Moore on August 6th about the use of the information he was going to provide to you. That is, what use you could make of it.
No.
How did you interpret Mr. Moore's statement, not for republication?
That this information was the property of the Ministry of Transportation and not the City of Hamilton. So he wasn't, and he was requesting that I not release it publicly.
When you say release it publicly, like what does publicly mean?
He was providing it to me for my information, but it was information that was the property of the Ministry of Transportation. So my understanding was he had asked for it not to be republished, presumably because that's what the ministry had told him when and if he got access to it.
Okay. And did you understand or interpret that this meant you couldn't publish it in any report prepared by SEMA?
Well, I would not have if it had not been released by the MTO, and Mr. Moore's note specifically indicates not for republication. So any inclusion in a SEMA report would be a violation of that property ownership that the ministry has of the information.
Okay. Registrar, can you go to OD 37, page 37, paragraph 109?
Sorry, Council, I didn't catch which OD document.
7.
7th? Okay, thank you. Sorry, I put up 6.
Thank you. So you see in paragraph 9, if you could call that out, Registrar. So you respond on the same day. And you ask some questions about where the data is coming from and about FN numbers. Why did you ask these questions?
Sorry, why did I ask the questions?
Yeah.
I was trying to understand if the city had interpreted the data.
You reference, I've also read that FN numbers greater 35 or higher in a zone would suggest skid resistance is not an issue on the pavement. Do you recall where you read that FN numbers greater 35 would suggest that skid resistance is not an issue?
I don't recall a precise publication, no.
Do you understand how friction numbers are used in geotechnical design manuals?
Geometric design, you mean?
Pardon me, yes.
Yes.
Do you have did you have at this time any existing knowledge about friction levels and what they signify in those design manuals?
Yes.
Can you explain those, what that knowledge was?
I understand how friction values are incorporated into geometric design, both for stopping site distance design components, which would be longitudinal friction aspects, and for horizontal curve design, which would be lateral friction components. I understood the fundamental parameters which are used in the prevailing geometric design guide for urban roads, which is the Transportation Association of Canada. They use a different nomenclature to some extent. They use a decimal system. So there are friction numbers provided for stopping site distance and for lateral friction for curve design in the manuals. So I'm aware of what those numbers are and can correlate them to a friction number as potentially is determined from field investigation.
What would the correlated friction number be from those decimal references?
For lateral friction on curves, I apologize, I don't have the manual in front of me, so it would be dangerous to recall, but it's in the range of 0.19, which would correlate to 19 as a friction number for lateral friction through horizontal curves. And for stopping sight distance, the friction number is typically 0.29, I believe, for 90 kilometer per hour design speed, or 100 kilometer per hour design speed, pardon me. But I'd have to double check that with the manual. I apologize.
No problem. So in terms of the ladder, is there a correlated friction number that you can use?
Well, the crude correlation is simply the 0.29 is equal to 29.
Okay.
The challenge is that the mean, it's a theoretical number. So the means to measure friction, there are a variety of measurement techniques that can be utilized. And so it was my view, and still is at the time, that it's a bit dangerous to do a direct comparison between the theoretical number in the geometric design guides and the number which is determined from whatever measurement technique you're using in the field.
Okay, thank you. Registrar, can you go to OD7, page 39, paragraph 116? Thank you. So, Mr. Merlin, I'm happy to take you the underlying document, but this reflects Gary's response to your email with his responses in red. Do you remember receiving an email in that format where he's putting in his answers into your initial email?
I do, yes.
From Mr. Moore's responses here, what did you conclude about whether or not the city had conducted its own friction testing?
Well, Mr. Moore responded to a couple of questions. One of them was I think it's below the line here, if I got it right. Oh yes, no, it's the very bottom line. It says testing was done by MTO both times. So I would say they are comparable, meaning the numbers that were in the two groups of testing. So my understanding from the response from Mr. Moore was that friction testing had been done in 2007, which would have been just prior to or immediately at the opening of the Red Hill Valley Parkway. And subsequently, friction testing had been done by MTO, not by the city, in 2013. So my conclusion was that the city had not done any friction testing on the Parkway. And the indication was that there were 2 rounds of tests that had been done. I'm assuming the 2013 one would have been prior to the completion of the 2013 report anyways. No other information was provided about friction testing being done by the city.
Okay. And you concluded that the testing in 2007 and the testing in 2013 had both been done by MTO?
I didn't conclude that. I was told that by Mr. Moore. So
thank you.
I accepted the statement that he made, that testing was done by MTO both times. So I would say they are comparable. That was his quote, not mine.
Did you take any steps to confirm with other city staff if friction testing had been done expressly in response to SEMA's 2013 recommendation after you received this email?
No, I didn't. I had spoken to Mr. Moore and asked him that question, highlighting that friction testing had been recommended in our 2013 report. And the previous email was what he had responded with. So I understood that to be a conclusive answer from the city, from the person responsible at the city for friction testing, which would have been Mr. Moore on the Red Hill Valley Parkway, as being an indication that it had not been done. So no, I didn't check with others because I had a conclusive answer from the city.
Did Mr. Moore's responses in this email provide you with clarity as to whether the city had a friction assessment process?
Well, it provided me with an indication that they did not have a friction assessment process. MTO, the bottom of the first paragraph, the question was about the friction numbers from the MTO report, and his response was, "Don't know," is indicative to me that there wasn't either there wasn't an understanding of the interpretation of the MTO results, or they didn't have their own internal process to do an assessment. And the next paragraph as well, it also highlights, not a city specification.
When Mr. Moore told you that the testing had been done by MTO both times, did you accept that statement at face value?
Yes, absolutely.
When Mr. Moore told you that the test results from 2007 and 2013 were comparable, did you accept that statement at face value?
I accepted what was written in this email. I wasn't sure what interpretation had taken place, particularly in respect to some of the responses that are in red in this email. So I can't say that I had any confidence that there wasn't an interpretation of the MTO data, but to be honest, I can't say that there wasn't. It was just data done by others, not by the city.
Did you contact anyone at the Ministry of Transportation to discuss the friction test results that Mr. Moore sent you?
No, I did not.
Why not?
Because this information that the ministry had conducted friction testing was simply confirmation for me that the city itself had not conducted friction testing in accordance with the recommendations that we had in the 2013 report. And our recommendation was that the city could conduct friction testing on their roads, and the city, with the intent that the city would interpret those results and make their own determination as to what to do with those results. Mr. Moore, by the provision of this information, confirmed for me that the city had not done that. And so it was frankly not relevant to me that the ministry had done it. It was not a ministry highway. I was aware of that. We had suggested the city undertake their testing, the city evaluate their friction results. And so I didn't have any results from the city to comment on. So I didn't think it was relevant that the MTO information in the context of what I was trying to understand which was whether or not the city had done friction testing.
Okay. Mr. Moore stated in his response that MTO keeps friction testing numbers, quote, close to the vest, or this info very close to the vest, end quote. Did you know at the time whether that was true or not?
No, I did not.
Did you know whether any other municipality had a performance specification for friction levels?
If you're asking in the context of a specific friction number, is that the context of the question?
The context of the question was, you asked Mr. Moore, do you have a performance specification for the FN value strive for? And my question was, at this time, did you know if other municipalities had performance specifications for an FN value?
No, I did not at the time know whether or not other municipalities had a performance specification for a specific FN value. I was aware that some municipalities had friction evaluation capabilities, or at least would undertake that on occasion on some of their roads. But generally, friction measurement and evaluation and a performance specification for friction was not a standard part of work that I would be involved in. And from my understanding, was not part of normal design, maintenance, and operations either.
Okay. Early you said that geometric design manuals dealt with friction levels, and we went through that, I think what you called the crude correlation. Just to ensure that I have your evidence on this, where did you get the information that a FN number less than 30 was below a desired level, if that in fact was your evidence.
I didn't, I don't believe I stated that earlier. I didn't know where the, I don't recall where I received any basis for that question. Obviously I got somewhere. I am familiar with the geometric design guide that indicates a friction number for stopping sight distance at 100 kilometers an hour, which I believe is 0.3, which is 30. So that the 30 number or 0.3 number in the TAC guidelines, 0.30, is considered to be a friction value which is incorporated in terms of undertaking design. When you design a road for stopping sight distance, you incorporate a friction number as well as the curve radius and the perception reaction time and the braking distance required. And so the friction number comes into play in terms of understanding what stopping sight distances may be required at given locations. And similarly, friction value is incorporated into the calculation for horizontal curves, taking into account the radius of the curve, super elevation, and the friction value assumed to be available on the road surface.
Okay, so apart from that explanation from design manuals, do you have any other recollection for the comment in this email where you say, am I correct that FN numbers of less than 30 are below the desired level?
I think I've already answered that. I don't.
Anything else besides what you told us? Sorry for interrupting.
I don't recall the specific reference that I made, and the TAC reference would be the most critical one in my mind.
Okay. We've already gone through the attachments to the first email. Mr. Moore didn't provide to you at any point a copy of the Tradewin report, did he?
Mr. Moore never did. I only received the Tradewin report in 2019.
On August 7, 2015, did you know that the Tradewin report existed?
Similar to the previous answer, because I didn't receive it until 2019. No, I had no idea what it was. It was explained to me in this email from Mr. Moore that both of these studies were done by the MTO. Tradewin didn't mean anything to me at the time.
Okay, and Registrar, if you can close that call out. And just and go back into CIM 10018. So just for clarity, in the email in the lower email from Goldar, where it says in 2013 the friction numbers were measured on the RHVP in both directions by Tradewin Scientific using a grip tester, and then their average FN numbers are as follows, and then there's 4 rows. My question specifically was, did you know of the existence of a report prepared by Tradewin at the time in August of 2015?
Based on this email, I knew there was friction testing done in 2007 and again in 2013. I questioned Mr. Moore, and he confirmed that both of those were done by MTO. Tradewin Scientific did not mean anything to me at the time, so I didn't know what it was. I did not have the Tradewin Scientific report. It was not provided as part of this attachment, and the first time I ever saw it was in 2019.
Okay, and Mr. Moore never conveyed to you the fact that such a report existed?
I never asked the question. He never conveyed it. He confirmed that these 2 sets of testing were done by MTO.
Did you ever expressly, ever in 2015, expressly ask Mr. Moore to provide you with all of the friction test data and reports that Dr. Zarowski refers to in this email?
I never asked Mr. Moore for any friction testing results. My concern, my focus was on the recommendation we had made in 2013 for the city that the city could undertake friction testing. I was seeking an understanding as to whether or not that had occurred. And based on this email and the series of responses that followed, it was my understanding clearly that the city had not done that. So no, I didn't pursue further this information because this was confirmation that the city had not done, or sorry, confirmation had been provided that the city had not done friction testing. That's the only element I was trying to validate in the series of emails and subsequent responses.
Thank you. Registrar, can you go to OD 7, page 39, paragraph 118, please? So you send that exchange with Mr. Moore to your colleagues at SEMA, and you say it doesn't help much because it appears that the city abdicates responsibility for assessing friction on pavement surfaces to the MTO for some reason. What did you mean by abdicates responsibility?
Well, I think the intent of the sentence was informing my coworkers that the city had not done friction testing on the roadway per our recommendation in 2013. And we had been relayed some information from the MTO. And so I think my interpretation was that the city may be relying on MTO, or I used the word abdicates because it appeared that the city was not responding to the request suggestion that friction testing should be done. They simply provided me with some information of friction testing that had been done by others.
Thank you. And if the city had conducted friction testing in 2013 and provided it to you in 2015, how would you use the friction testing that had been conducted, 2 years prior? What use would that be to you?
I wouldn't use the friction testing results. What I was looking for was information on the city's use of friction testing results. So the purpose of the original recommendation in 2013 for friction testing was for the city to gather additional information and come to some conclusions internally as to their assessment of the friction of the pavement surface. We did not know, as we were undertaking the SEMA's safety reviews, both in 2013 and again in 2015, what friction values were. It was not our task to measure friction, because that is something that the municipality needs to do using whatever technique and method they elect to set their baseline and standard. I understand friction values in the realm of design and operations, but the determination as to whether or not your pavement surface friction is sufficient is a decision that the road authority needs to make themselves using whatever analysis techniques they have decided to utilize. And so in response to your question, my comment, perhaps flippantly, was that the city was abdicating that responsibility to the ministry, or perhaps a better wording would be that the city was not assessing friction. They just relayed some MTO information to us.
Given your experience as a road safety expert, would you have expected that the city would have a friction assessment program?
I would expect the city would have the capability of assessing friction. I can't comment as to whether or not they should have a friction assessment program in a formal sense with some sort of regular testing and applications and measurements. Friction values are defined in the geometric design guides that we've discussed. And so there's an understanding that if you're going to operate a roadway, you need to have those friction values, because that's what has been built into the design. And then the road authority needs to make their own determination as to how or whether or not they're providing that friction value on their road surface. It's not a decision for SEMA to undertake. It's a operating decision by the municipality.
In this email, you say, we'll need to decide how to deal with this in the report. Why not just put it into the report? This being the 2015 report that SEMA is working on.
Well, no, the question is whether or not we should be including the call for friction testing in the report. We had included that in the 2013 report, and it was apparent to me based on information provided that friction testing had not been done in 2013. We were contemplating including friction testing in the 2015 report. We were reviewing new areas of the highway, so there would have been a call for friction testing to be done on the new portions that we were reviewing based on new information anyways. But this simply reinforced the fact that no friction testing had been done so far. So we weren't, the reporting of the friction numbers would never have been in our report. The report was recommending that friction testing and analysis be done by the city. And what we did was include that recommendation again in the 2015 report with more forceful language.
Okay, if you had, you said reporting of friction numbers would never have been done in the report. But if you had city produced, city conducted friction tests, might that have assisted SEMA in determining the appropriate countermeasures?
No, we had highlighted countermeasures to deal with what was potentially poor friction on the roadway. Mm-hmm. And those countermeasures were identified and listed in the report. The city needs to make a determination whether friction was in fact the causal factor in crashes. I mean, the challenge in the safety review is that there are multiple potential factors that lead to collisions occurring. Friction will, because of the preponderance of wet road crashes, friction was one of the potential causes without sufficient information having been gleaned as to whether or not friction was problematic. But speeds were another concern. The curvilinear alignment of the highway was another concern. And it's impossible to know which was the causal factor of collisions as opposed to a correlated factor. So simply knowing or listing the friction numbers that would have been in the MTO report would have served no purpose in SEMA's report. We're not assessing the friction on the road surface. What we were saying to the client is they should assess friction on the road surface because that may be something that they need to assess. Similarly to the way speed should be assessed. We made comments in the 2015 report about the need to assess speed. And we highlighted that that information is useful and needs to be interpreted by the city.
Okay, well, why don't we go into the report, the first draft of the SEMA report that was sent to the city in September of 2015. Registrar, can you go to OD7, page 40, paragraph 122? So this is the transmission of the draft 2015 report. You see it September 6th. Registrar, can you close that out and can you go to CIM 10146.0001? So this, like others we looked at, is your general logo. And this is your B558 project number. It says draft report, September 2015. I don't see on this unless I'm not looking carefully, your numbering system. Your E's, EO1.
It's embedded in the file name.
Okay. Registrar, can you go to image 3, please? Image 4, please. Thank you. So I'm just going to go through the table of contents so that we're not going through all the details. So as set out in that task list, and very much like the 2013 report, SEMA did a review of collisions for the entire Red Hill. Is that right?
Yes.
And you also did a field investigation.
Yes.
You did an illumination review, which is right on the bottom of that page.
Yes.
Registrar, can you go to the next image, please? You determined a number of potential countermeasures, signage, let's see, friction testing, illumination, delineation, and then median barrier, which was one of the issues Mr. Ferguson had raised with you. Then you did the cost benefit analysis, and then you did recommendations. So very much the same sort of format as the 2013 report, right?
Yes.
Okay, so I'm going to go to page 17. Apologies, that is image 17, and it is, what I'm looking for is image 24. There we go. So you've had, I'm not going to take you through it, but you've gone through a summary of the work you've done and the conclusions on the collision review, and then you have a summary where you have identified wet weather collisions were found to represent approximately 50% of all collisions in the study area, which is significantly high compared to typical proportions. What do you mean it's significantly high compared to typical proportions?
Well, I think we compared to provincial data, and normally on any road, any given road, the number of collisions in wet roads is not as high as 50%. It's significantly less than that.
You also find that single motor vehicle collisions amounted to 44% of all collisions in the study area, followed by rear ends and side swipes. And was that a higher? It's higher compared to typical proportions.
I'd have to double check. I don't see that we referenced that specifically in this summary.
Okay. You also say that the most frequent apparent driver action was lost control, followed by some driving properly, speed too fast, and both lost control and speed too fast are significantly high compared to typical proportions. So there, that a driver action, is that based on the collision history records that are being reviewed?
It's based on information provided in the motor vehicle accident reports as reported to the police. There's sometimes challenges with the accuracy of that information.
Okay. Registrar, can you go to the next image, please? So you have under critical locations, and then at the very top, you've identified a northbound direction, one particular section around the King Street interchange, a southbound direction, the on-ramps at various roads, and all locations with the highest collision frequencies are located within or on the approach to or leaving horizontal curves. And then you've also separately set out median-related collisions. And the critical locations for median-related collisions. Registrar, can you go to the next image, please? So here, and if you could call out, Registrar, under potential contributing factors to collisions and down to excessive speed. So just as an overall finding from the collision review, you indicate that the proportion of wet weather surface collisions in the study area was significantly higher than typically observed in the city and in the province. We've already gone through that. And you said that a proportion of wet weather surface condition suggests one or more of the following conditions may be present: inadequate skid resistance, hazardous maneuvers, and excessive speed. And is that conclusion based on the nature of wet weather conditions? Or is there something specific about the conclusions you found here that led you to those three conditions?
Those three bullets are generic elements for linked to wet surface condition collisions. It's taken from the what's called the PIARC Road Safety Manual as the reference number 9.
Okay.
It's a generic description of types of factors that may lead to wet surface conditions, or wet surface collisions, excuse me.
Okay. Like yesterday when you said that you look at the road, you look at the vehicle, and you look at the driver. So here you're looking at aspects of those and related to wet surface conditions. Is that these are the same sort of generic statements that are possible contributors to wet surface conditions? Is that right?
Yeah, I think the one that's probably not listed here, which would be the horizontal alignment as well, curves in the roadway. But these are the generic factors. If you exclude geometric elements that would be possibly linked to wet road crashes.
Okay. Registrar, can you cancel this call out and call out the next 3 paragraphs? Thank you. So you also reference driver actions in the study area, and another indication being high speeds may be involved, and the consequences of improper lane change may be aggravated in high speeds and wet surface conditions. So these were all just a summary of the potential contributing factors to collisions. Is that right?
Yeah, I think so. Correct.
Recognizing that this is a study of the entire Parkway and 2013 was a smaller study area, how did the 2015 collision review compare to the 2013 collision review?
There were significantly more collisions on the mainline portions of the highway, particularly related to areas where there were horizontal curves, as opposed to the 2013 study, which was to the south. The focus there was on the interchange and the ramps, particularly what was called ramp 6 at Mud Street. Still a geometric correlation there, but the location was ramp as opposed to mainline. So in this section of the highway, there were greater number of collisions that were associated with located in conjunction with the horizontal curves.
Was that an unexpected finding when you went into this? Were you predicting that that's what you were find? That is what you would find?
We try never to predict. The purpose of the study is to do the evaluation. So we come in with a clean slate in our assessment. It's not unusual to find collisions associated with a curve because that's where the physical limitations of the roadway, in that it curves instead of going straight, have the potential to result in collisions. If a driver doesn't see the curve, they drive off it, that's a collision. So you have to physically interact with the road if you're driving through a curve. So it's not uncommon that collisions will occur on curves, and it's not uncommon that there will be more collisions at curves, but we never presuppose what the outcome is going to be.
Okay. Registrar, can you call up image 29 and image 30? So this is on operating speeds, and the report indicates that you reviewed speed studies conducted for the 2013 RHPB study. Registrar, can you just highlight that? You don't need to call it out, but it's the third the second line on image 29. SEMA reviewed the speed studies conducted for the 2013 speed study. Thank you. So SEMA did not conduct speed studies itself in advance and for the 2015 SEMA report. Is that right?
We didn't conduct speed studies. The city provided us with speed study data, and the data they provided us had been the same data that was provided in the 2013 study.
Okay. And on image 30 at the top, there's a table for the RHVP operating speeds. That's the results of the speed study being from 2013 being summarized in table 5. And just above that table, it says an average of more than 500 vehicles per day were recorded exceeding 140 kilometers per hour. You see that?
Yes.
And I understand that this later became a controversy. This average of 500 vehicles per day were recorded exceeding 140 kilometers. To your knowledge, this information came from the 2013 study. Is that right?
That was my understanding, yes.
And it was conducted by Pyramid on behalf of the city?
Well, the city provided us with the data, and I believe their contractor was Pyramid.
And did you have any, at the time when you were preparing the 2015 report, any reason to doubt the accuracy of those speed studies?
No.
And did you have any concern with using speed study data that was at least a couple of years old?
Not particularly. Speed study data tends to be fairly static. The roadway had been in operation since 2007. So data that was from 2013, when we're undertaking our study in mid 2015, was not, I would believe it would be fairly accurate. I wouldn't expect speed data to have changed significantly. Newer, more recent is better, but I wasn't overly concerned by the lag in time.
Okay. In the paragraph that is under table 5, you reference a ball bank indicator study to gain additional understanding of the potential collision contributing factors. Can you explain what a ball bank indicator study is typically used for and how you used it here?
I can try. A ball bank study is an empirical test that's conducted in a moving automobile. It uses a measure which looks like a level on a curve, and it seeks to measure forces that an occupant of a vehicle would feel as they travel around a corner. So if you go around a curve at a slow speed, the measurement device would give you an indicator of degrees of angle, these numbers that are listed as the ball bank readings, 10, 12, whatever. And if you go around the same curve at a higher speed, the angle measured would be higher. And there are tolerances provided in industry guidance that indicates what is an acceptable measurement for selected speeds as you travel through the curve. I hope that helps.
It does. And what conclusions did SEMA come to in respect of the vicinity around King Street and Queenston Road, those interchanges, after completing the ball bank indicator study?
So just to back up half a step, the ball bank indicator gives you an indication of what's called the advisory speed through a curve. Mm-hmm. So the curve, the roadway, has been designed in accordance with some geometric design parameters. The ball bank, and you can measure the advisory speed through the curve by doing a mathematical calculation. But the ball bank provides a similar analysis that's an empirical test It considers the radius of the curve because you're traveling through the curve, considers the speed of the vehicle as you travel through the curve because you measure it at different operating speeds. By default, it takes into account the friction which is provided as you travel through the curve, and you end up with a determination of the degree of the sensitivity as you go through, and make a conclusion as to what the advisory speed should be through the curve. So long story short, the answer that was concluded in assessing these three curves was that the advisory speed through the curve in question, I can't remember exactly which one we're talking about here, was that the advisory speed was 100 kilometers per hour. That's not the speed at which you are physically capable of traveling through it. It's just an indicator as to what would be a comfortable speed for motorists, is the word used in the guidance.
Thank you.
And you supplement the results of the ball bank study. You use that to help make determinations as to whether additional information needs to be provided to motorists in the form of an advisory speed tab. So if you, I'm sure you've experienced it in your driving, you'll see a curve warning sign on the roadway. And in some locations, there will be an advisory speed tab below that, some measurement which is less than the posted speed limit. That's what the ball bank study is for, is to help you make a determination whether or not you need to provide an advisory speed tab in conjunction with the curve warning information which is present.
Thank you. Registrar, can we go to image 32 now, please? So turning to pavement surface, the draft of the report references stone mastic asphalt, and there are two references that are footnoted. Who drafted this and found those footnotes?
I don't remember precisely who drafted it. I could take a guess, but I won't do that. It wasn't me. And sorry, the second part of your question was?
Where did those references come from?
I'd have to look at the references. I can't, maybe it's in the bottom, sorry.
Maybe I'll put this question differently. To your knowledge, was this research that was done internal to SEMA, or was this information that was provided from some other source?
As referenced in the bottom of the report, or the bottom of the page, there are other references. They're not done by SEMA.
Okay. But they were, these references were researched by SEMA. They weren't prepared. They weren't provided to SEMA from the city.
I don't believe they were provided by the city. We didn't do the research. We are referencing research which was done.
Yes. Okay. The second paragraph says one industry identified characteristics of SMA pavements is that skid resistance is lower in newer surfaces. So this is the early age low friction problem or issue from that paper that Mr. Moore sent you. Is that right?
I don't think it's actually the paper Mr. Moore referenced, but I think it's the same phenomenon which is discussed in another paper.
Thank you. Yes, I meant the phenomenon that we're talking about. By this point, had you personally undertaken any further research about early age low friction issues with SMA?
I'm sure I had after the discussion with Mr. Moore, and that likely led to the internal discussion at SEMA that led to the inclusion of this. I don't believe I did this particular research, but it would be a bit of a collaborative effort, so potentially.
Okay. And here, the draft says the proportion of wet surface collisions seems to be increasing over the years. And then there's a caveat in the footnote. This suggests that if low skid resistance is a contributing factor, it's not necessarily related to normal early life properties of SMA pavements. And that was the premise on which you were proceeding, that this was not an early life friction issue. Is that right?
I think what we were trying to do was include in the report that component, that element of the early life lower friction values in SMA asphalts to assist the city in some context of analyzing utilizing the recommendations that we were going to be providing them.
Okay. Registrar, can you go to image 41? So this is in the recommendations section, and just continuing with pavement surface. One of the recommendations set out in this draft that we're looking at is to perform friction tests or friction testing. And you say in the second paragraph, because of the high proportion of wet surface condition and SMV collisions, the city could consider undertaking pavement friction testing on the asphalt to get a baseline friction coefficient to which to compare to design specifications. So I know you talked about this yesterday, but again, can you unpack why SEMA thought that pavement friction testing would provide value to the city?
Well, I think the simplest answer is perhaps an analogy to say, if, for example, we didn't have any traffic speed information, then we would have recommended that speed studies be undertaken so that you can understand what's happening with speed. Speed would be a potential causal factor in collisions on horizontal curves. And so collection of speed data would assist in understanding if that contributes. And friction data is in a similar category. In this case, we didn't have any friction information about the road surface. We had measured it, to some extent by proxy with the ball bank studies, but it's not a direct, by any means, friction measurement. But of course, as you travel around a corner undertaking a ball bank, you are engaging the friction of the tires on the road surface. So the point was that friction information input is needed by the city in order to investigate whether or not friction is a causal factor, contributing factor to collisions. And we had recommended that in 2013, and we were priming up to recommend it again in 2015.
Okay. In 2013, SEMA recommended the overlay of a high friction application on a few different places, but I'm going to specifically focus on ramp 6. During your work in 2015 for the 2015 SEMA project, did you confirm whether that recommendation had been implemented?
No, we didn't confirm whether or not any of the recommendations from 2013 had been implemented. We had no follow-up project to undertake the review of those recommendations.
I don't want this to be a memory test, but in respect of ramp 6, in the 2015 SEMA report, you reconducted collision review on ramp 6, right?
Sorry, we?
Did SEMA reassess or reconduct a collision review in respect of ramp 6?
If information had been provided updating the crash information, we would have updated our information. I can't recall precisely whether we did or not. I'm assuming we had overall update of collision information, so ramp 6 should or would have been included in that.
Okay. Registrar, can we go to image 40, please? No, apologies. It's image 38. Thank you. So just turning now to illumination. Pardon me for saying you, I mean to say the report. The report indicates that the primary objective of illumination is to increase safety. And the report mentions design choices that were made during the design phase that were intimately linked to approvals. And so there you're talking about environmental constraints and approvals, is that right?
Yes.
In advance of preparing this draft, had SEMA obtained further information about the specific environmental constraints that were assessed during the design phase?
Not to my recollection in any detail. I think we had some of the basic information that allowed population of this content, but we didn't have the full environmental assessment history and records and all of that.
Okay, and there are some references footnoted there. Do you recall whether SEMA went to try to find that information on its own, or whether the city provided information about to populate the drafting that we've just looked at here?
I don't honestly recall exactly which. We could have done it either way. Some information is publicly available, and search the internet. I know we requested information, and various things that we asked for were not provided or not available from the city, like the geometric design plans for the roadway, for example, we were told they were not available.
Okay. The next paragraph goes through the warrant process, which we've already talked about. Registrar, can you go to the next page and the next image, please? Under table 9, there is results of the TAC warrant and the MTO warrant that SEMA conducted, and both indicate that they are warranted. Just for clarity, that warranting, that was for the entire illumination of the Red Hill. Is that correct?
That's my understanding, yes.
In the paragraph between table 9 and table 10, it says the MTO warrant provides additional criteria based on the benefit cost ratio. So I believe you said yesterday that there's some differences between the TAC warrant analysis tool and the MTO warrant analysis tool. And do those differences reflect the differences between the warranting condition of 60 and 80?
They're similar, but they're not the same tool. There's some differences between them. And as highlighted, the MTO applies to MTO highways, roadways. I would need to open up each warrant to review the differences, but there are differences. They use a different number. So
I am not going to make you do that. Is one of the differences between the MTO warrant process and the TAC warrant process the cost benefit calculation that plays into the warranting threshold? Is that correct?
Yeah, it's stated in the paragraph between the two tables.
Okay. And so in this case, the table 10 sets out the cost benefit ratios and the warrant. And this report goes on to say that illumination, this is the next paragraph underneath the table, illumination will be warranted if the benefit cost ratio of providing it is greater than 1 and optional if otherwise. And then we're going to come back to that in a moment. But before we go there, the next paragraph talks about other factors to be considered, including wildlife and driver's eyes and other things. So you're providing a fair bit of context to consider whether to do illumination, even if it is warranted. Is that fair to say?
Yeah, I think we're giving some more complete context with respect to the potential for consideration of illumination in the context of the Red Hill Valley Parkway. there are other factors, as with any warrant, there are other factors that must be considered. Engineering judgment must come into play.
Okay. Registrar, can you go to image 42, please? 42. Actually, sorry, I think we'll start on 41. Maybe you can, if you can show image 41 and 42 at the same time. There we go. So the bottom, it says the primary objective of illumination is to increase safety. We've already said that. And it says, as discussed in section 6, continuous illumination along the Red Hill is either warranted or optional, although restrictions from the approvals phase may result in an undesired condition where illuminated and non-illuminated sections alternate. And then you set out the cost that CMF for this countermeasure. What is CMF?
CMF is collision modification factor.
And then you said it expected construction costs. For this, where you say continuous illumination is either warranted or optional, SEMA concluded that it was warranted. Is that right?
What we concluded was that the warrant was met. What we're highlighting is the context of what potential benefits come from installation of lighting. So there's a CMF indicated. CMF is the potential for the countermeasure to modify, change the number of collisions that might occur. As you can see, it's very close to 1. So the collision reduction value of lighting is not terribly good. And so that comes into consideration when you're doing the benefit cost analysis.
Okay. I have some additional questions on this, Commissioner, but I do know the time and I want to be mindful of our regular lunch break. Would you like me to continue? I probably have another 5 more minutes on this, and then I'll wrap up to another topic.
Thank you. Why don't we conclude this topic if it's going to be 5 minutes?
Thank you. Registrar, if you can go back to that same document, CIM 10146. And if you can go to image 55, please. Oh, I'm sorry. It's CIM 10146.0001. Image 55. So, Mr. Malone, we did not go through all of the countermeasures that were suggested here, but SEMA did provide a summary of it says at the top: prioritized list of countermeasures. The priority has been assigned based on ease of implementation, importance, ability to reduce collisions, and ability to reduce severity. So you'd agree with me that SEMA turns its attention to how to characterize a timeline for proposed countermeasures based on the factors that are set out in that paragraph. Is that right?
Yeah, and the client had requested a timeline to be included in the report.
Okay. And do SEMA's recommendations on timelines or timing ever reflect its views for the urgency for improvements from a safety perspective?
Well, I wouldn't use that terminology. Any recommendation that we provide is intended to improve safety. If they can be done instantaneously, then that potential improvement would occur at the same time. The real world is that some things will are able to be done quickly, and other things may require significantly longer periods of time, including, as discussed previously, if there's significant budgeting or capital budgeting required as opposed to operating budgets. So I think the timeline column that's provided here is primarily a reflection of the reality of installation and budgeting for the completion of. And I think that's sort of evident to some extent. If high tension cable barrier, for example, was installed tomorrow after the report was released, that would have the greatest impact of reducing crossover collisions. But it's a significant decision-making process. It had not been included in original design, requires extensive capital budgeting, planning and installation. So it is going to be a longer term before that can be achieved, as opposed to others which may be short term. So personally, I don't think that these are ordered in terms of imperative of safety improvement. They're all important for improving safety. That's why they've been recommended.
Okay. Thank you. So those were my questions in respect of this document, and I do think it's a good time before we move to another topic to take our lunch.
Okay. Well, it's almost 1:10, so we'll come back at well, let's say 2:20. Okay.
Thank you.
Stand adjourned until that time.
Thank you. Good afternoon, Mr. Malone. So we are going to move forward in time. Registrar, can you bring up OD 7, page 43, paragraph 131, please? So just a reminder, SEMA has sent the city a draft of the 2015 SEMA report. That was the document that we were just looking at. And on September 22, 2015, city staff attended a meeting with you and SEMA staff, and one of your colleagues prepared notes, which is set out at the top of page 44. Registrar, can you call that out, please? Thank you. So SEMA summarized findings and recommendations from both reports. Is that reference to both reports? Was SEMA concurrently doing the link safety review study?
Yeah, not quite concurrently. We had started the link report previous, but I believe that's what it's referring to, is both the link median crossover crash report and the report done for the Red Hill.
Okay. The next bullet point is a reference to the traffic management program. Were you generally aware of the city's traffic management program?
Yeah, the city was undertaking another review, another study relating to intelligent transportation systems and traffic management program for installation of message boards along the link in particular.
I'm just going to refer you to the last of the paragraphs here. SEMA to provide revised final report by October 6th. It says 2020. I think it is 2015, and that's just a typographical error. So you have about a month to prepare the final version of the report. Does that sound right to your recollection?
I don't recall the timeline exactly. It would have been between the first and second editions that were issued.
Okay. Do you recall any discussion in this meeting or at any point before your next draft where there was discussion about the potential for widening the Red Hill?
I remember some discussion about context of suggestions for improvements in the context of potential widening of the roadway. And I have seen documentation in review for this testimony, but I can't recall it all precisely.
Okay, that's fine. Registrar, you can close out this call out, please. Apart from what's in these notes that we've just gone through, do you remember anything else from that meeting?
No, I really don't have a great recall of the meeting.
Okay, turning now to the October, when SEMA had agreed to provide a revised final report. Registrar, if you can bring up OD page 46, paragraph 139, please. Thank you. Apologies. Can you take that call out down? That's not the call out that I wanted. Sorry about that. It's 138. Registrar, if you could call it paragraph 138. Thanks. So on October 7, your colleague sent city staff copies of the SEMA link report and the SEMA Red Hill report, and indicated if they had questions or comments to not hesitate, but these were characterized as the final reports. Registrar, can you go into HAM 672, please? So this is the attachment to that email that I just referred you to. And I'm going to take you, maybe I'll ask a general question. In terms of the recommendations around cat size and markings and signage, those recommendations, which we already touched upon, those didn't change in the various versions of the drafts of this report, did they?
I'd have to double check to be sure. I know that there was no change in the items that were identified for improvements in versions 2 and 3. I'd have to double check version 1 first.
Okay. Registrar, can you go to image 54, please? So we looked before the lunch break at an earlier draft, and now I'm going to take you to this draft. Registrar, if you can call out the section under 9.1.5. So in this draft, the SEMA report indicates, again, we've gone through this at the collision review, found a proportion of non-daylight collisions was higher than averages. And this version of the report says the estimated, a review of the MTO policy and warrant indicated that continuous illumination is warranted in the study area. And for this report, the study area is the entirety of the RHVP, right?
Yes, I believe so. Yep.
And this is continuous illumination of the main line?
Continuous illumination would be the main line, yes.
The report provides an estimated installation cost and the benefit cost number of 810,000 and 2.77. And then it goes on to provide with similar language as the document that we were looking at before lunch, other factors that need to be taken into account. And in the last sentence, all illumination must be assessed in relation to the environmental approval constraints which exist, as well as the cost of installation and maintenance implications. Registrar, can you now go to image 57? And so this is an updated summary table to the one that we looked at before lunch in the earlier draft. And you'll see under the line that says short-term total in the bottom third of the page, there's now 2 lines: install continuous illumination as a long-term option, or prioritize list of countermeasures. So it's a countermeasure there. And then install high tension cable guardrail. And both of those are under long-term, and they both have some comments beside them. And so by this version, the October 7th version of the SEMA report, SEMA had now included the continuous illumination warrant, the estimated installation costs, the benefit cost number, and had included as a long-term option install continuous illumination. Do you agree with that?
Yes.
So at the conclusion of the project to complete the 2015 SEMA report, you viewed continuous illumination of the main line as a responsible recommendation for SEMA to make?
It was a countermeasure which was listed amongst the ones for the city to undertake, yes.
Okay. And nothing had changed regarding your understanding of the feasibility of continuous illumination between 2013 and 2015, correct?
Well, no, it's a different piece of roadway. So the earlier study only dealt with the portion from Green Hill to the south to Dartnell, and this portion covered the entire length. So there's different context in terms of feasibility because it's a different piece of roadway.
Nothing had changed in terms of the feasibility of the environmental constraints that you understood applied to the Parkway.
I think the report highlights that the environmental constraints are environmental approvals which had been which are in place had been identified, but the scope of work that we were provided for the 2015 assignment more clearly indicated that illumination was within scope, whereas the previous version, the 2013 portion, I should say, of the study clearly indicated that it was out of scope.
Thank you. My question was specifically about the feasibility, and maybe I'll just rephrase it. Between 2013, when SEMA prepared that report, and 2015, nothing that, to your knowledge, there was no change in terms of the environmental approvals on the Red Hill.
Well, there's two different things. I agree with your second part of your question that yes, there's no change to my understanding to the environmental assessment approvals that had previously been identified. The feasibility of lighting or not is a different decision when you're looking at the entire 8 or 9 kilometers of roadway instead of 4 kilometers that were reviewed in the first portion.
Okay, thank you. Registrar, can we go back to OD7, page 46, paragraph 139? If you can call out 139, including, actually just call out 139, that's on page 146, please. Thank you. So on October 20, you and 2 of your colleagues from SEMA met with Gary Moore, David Ferguson, and Martin White to discuss the 2015 SEMA report and the 2015 SEMA Link report. And one of your colleagues prepared a meeting summary. I'll turn to that meeting summary in a moment, but before I do you recall who asked for this meeting?
I don't really. I would suspect it would be the city, but I don't recall. I certainly don't recall the individual.
I'm sorry, I missed that last part.
And I said I certainly don't recall the individual.
Okay. Do you recall Mr. White, Mr. Ferguson, and Mr. Moore attending this meeting?
I don't have a great recollection of this meeting, so if the minutes indicate so, then I believe that would be the case, but I don't have an image in my mind of them.
Okay, I'm going to pull up the meeting minutes just to hopefully refresh your memory or at least orient you. It's CIM 9287. So you'll see at the top, and you can see the commissioner looking. So I'm going to try to pull this out a little bit more. Under persons present, Registrar, can you pull out the box that has persons present? Sorry, the left side of that one. So there we go. There's the attendees. Is that helpful to recall this meeting?
The meeting summary is helpful. I still don't have a specific recollection of it, but I trust the meeting minutes.
Okay, you can take that, call it down, please. The location is listed as 1375 Upper Ottawa, if that assists to orient to this meeting. Were you given any guidance from anyone at the city in advance of this meeting about what to address during this meeting?
Not that I recall. If we did, it would probably have been listed in an agenda for the meeting, and I don't think there is one.
I think one has not been provided to us. Do you know why Mr. Moore was present?
I assumed he would be present because some of the items that are listed in the report are fairly major capital expenditures, lighting, and so on and so forth, guide rail, and those would require design input as opposed to the level of items that would typically be dealt with by Mr. White and Mr. Ferguson.
Registrar, could you call out the third to last and the second to last bullet points on this page? The one that starts Mr. Moore stated and SEMA clarified. Thank you. So this is, I just before I put the call out on, this is BM summarized findings and recommendations from the RHBP report. And then this is the next bullet. Mr. Moore said that friction testing was conducted recently following standards and resulted satisfactory. Do you remember anything else about what he said about friction testing?
I don't. I understood that to be referring to the previous exchange in email that we talked about on August 5th, 6th, and 7th. So that was the context of it, but I don't recall anything more specifically than that.
Did he specify which friction test results he was talking about?
I don't believe so. I'm not sure if it would have been noted in the minutes, but I don't have a recollection of that.
You said you understood it was about that previous exchange. Did he specify that he was talking about MTO conducted friction testing?
I can't recall that level of detail from the discussion, so the minutes will have to reflect.
Did he mention, that is Mr. Moore mentioned Tradewind during this discussion?
Not to my recollection.
Did he offer to provide the test results to anyone at this meeting?
Again, not that I recall. It would have, I assume that would have been indicated in the meeting minutes, meeting notes, if that had been the case, because that would likely be a follow-up action.
At this point in SEMA's work on this project, having provided what one of your colleagues identified as a final draft, would you have been interested in receiving friction test results?
No, not really. The input from the report in 2013 and again in 2015 were was for friction testing to be undertaken by the city, not for SEMA to review friction testing results. So if Mr. Moore is stating that friction testing has been done and his results are satisfactory, then that would be an indication that he has followed or accepted the input that was provided in the 2013 and 2015 reports. So we were not seeking to get the friction results. It's not something that SEMA was reviewing. We were asking the city, recommending, suggesting to the city that they undertake friction testing because it may be a causal factor and there appeared to be an absence of information.
Did Mr. Moore tell you during this meeting that SEMA should reconsider the recommendation that it had put in the 2015 report to recommend friction testing?
Not to my recollection, no.
Did you perceive that Mr. Moore was attempting to persuade SEMA to remove friction testing recommendations from its report?
No, we never made a change. So no, I don't think that was the case at all. He may have had a different opinion. I'm not I'm not sure exactly what was going through his mind, but I don't recall any pressure on SEMA to make a change to the recommendations, the inputs that we had to the report.
Did Mr. Moore provide any commentary about the very idea of friction testing as not having value?
Not directly that I recall, no. You're talking just to make sure we're on the same page in the context of this meeting.
In the context of this meeting.
Yeah, I mean, I've since read other materials, but in the context of this meeting, no, I don't recall that occurring at all.
Okay. And leaving out of your mind materials you may have read to prepare for today, in your personal observation, did Mr. Moore ever convey to you a view that friction testing as an idea, as a concept, was without value?
I never got that direct input. No, not that I gleaned from my interactions with Mr. Moore.
Okay. The second bullet point in these minutes say, SEMA clarified that actual weather conditions occurring on the Red Hill may exceed typical testing conditions, and more rigorous testing should be undertaken in order to rule out pavement friction as a problem. Speeding is definitely a contributing factor, but the contribution of pavement should be ruled out. Do you remember who, as amongst your colleagues at SEMA, provided this clarification?
I don't precisely. I suspect it was me, but I don't remember.
Do you recall if Mr. Moore had a response to that clarification or that information from SEMA?
I don't. If it had been significant, I think it would have been recorded in the minutes, and I don't see anything there.
And so when this commentary attributed to SEMA, which you or one of your colleagues made, said speeding is definitely a contributing factor, but the contribution of pavement should not be ruled out. In 2015, what was your view of the relationship between speeding and the condition of the pavement?
Well, both friction and speed are relevant as to the capability of a vehicle to traverse a curve in particular. And so both elements are ideally need to be understood in order to determine which or how much each has contributed to the potential outcome. Obviously, speeding is something that the driver selects, makes a decision to operate at a given speed, and friction is an aspect of the road itself. The driver doesn't have direct input on what the friction may or may not be. So both are important, and in this case, the preponderance of wet road collisions gave us an indication that the friction of the pavement surface is something that should be investigated, which is why the recommendation was in the report and the consideration was in the 2015 report.
Thank you. Registrar, can you close that call out and call out the very last bullet on this page? So this is also from the minutes, issues with illumination discussed, cost plus environmental restrictions. What do you recall, if anything, Mr. Moore said on the topic of illumination during this meeting?
I think I only vaguely recall that he highlighted that illumination would be a very expensive process, and that there were environmental restrictions referring to the environmental assessment approvals that have been discussed, that were hurdles that would need to be addressed in order to deal with the illumination commentaries.
Did you perceive that his comments were an attempt to persuade SEMA to remove the recommendation for illumination in SEMA's report?
No, not at all. He was providing input from his perspective, which was the design and construction side of the line, and that was valuable input. I believe we already understood that those fundamental components. Perhaps he felt it was necessary to identify the importance of them in the discussion, but no indication or suggestion to remove or change our recommendations or our inputs.
Okay, Registrar, can you close that call out? And can you bring up the next image side by side? And can you call out the bullet on image 1 that starts with discussion followed on the benefit/costs? It is this 7th bullet down. Thank you. And then if you can also call out the first bullet on image 2. Thank you. So Mr. Malone, the top call out here is under the summary in this in these minutes relate to the link report. Did SEMA undertake an assessment of whether there should be a median barrier on the link in the link safety review?
Sorry, could you repeat the question again? I was just reading the paragraph.
Sure. So this is under the summary of the discussion about the link report. Did SEMA, in its link safety review, discuss the installation of a median barrier on the link?
I have not reviewed that report as part of preparation for this questioning today, so I'd have to go back and double check. It was a review of median crossover crashes, and so I believe that median barrier was contemplated in the report, but I'm sorry, I haven't refreshed my memory on that content prior to this discussion.
That's fine. Here, do you recall in this meeting, and Mr. Moore indicating that he believed benefits would not offset costs in respect of installation of a median barrier, and says that current situation reflects the risk the city is willing to assume? Do you remember that part of the discussion in this meeting?
No, I don't really remember the specifics of it. I think the minutes reflect the input. I take it to be an accurate reflection of what was stated.
Okay. And then in respect of the part of the meeting that dealt with the RHVP report is the second call out. It says address speed and wet surface first and reevaluate benefit of median barrier. Overview provided on short-term measures. And so is it fair to say that the city staff were directing SEMA to focus on the countermeasures short of the median barrier before turning to the median barrier in its report?
I'm not sure who stated the sentence. I would highlight that median barrier does not prevent crashes. It mitigates the outcomes of crashes if there's an event where a vehicle enters and potentially is going to cross the median. So crashes continue to occur with median barrier, and in fact, you can potentially have more crashes because instead of cars just stopping in the median, they hit the barrier. So I think the sentence is reflective of a prudent approach, which would be if you can stop collisions from occurring, entering and crossing median, then that is a better solution because you don't need the barrier at that point. And in fact, if you have very few or no median crossover crashes, the barrier is more of a hazard than it is a benefit. So I think it's just reflection of the industry approach to the application and potential benefit of median barrier. but also the potential drawbacks.
And in the last version of the SEMA report that we just looked at, in fact, you'll recall it's the median barrier is a long-term countermeasure that is discussed. Do you recall that?
I do. I think it's long-term for two reasons. One is that it's capital dollars intensive, so it takes time to plan, design. There's drainage issues that would need to be addressed. Physically building it is a time-consuming and expensive process. And secondly, if you're able to reduce collisions through other means, then you theoretically potentially do not need the barrier at all. So if there are no median crossovers, you don't need a barrier to mitigate the consequences of those events.
So SEMA before this meeting had already come to the recommendation of suggesting short-term countermeasures, and then considering the effect of those countermeasures on collisions, and then moving to the median barrier as a second stage countermeasure recommendation. Is that fair?
It probably wasn't articulated that clearly in the report, but in reality, that's what occurs. You can do the short-term measures in just that, a short period of time. You would potentially be able to see the consequences, the benefits, ideally, of those measures that were implemented in short-term. And by the time you get to your long-term, you may be able to make the decision that it's not required. You can potentially initiate the process of both of them at the same time. It's just that the actual implementation of a median barrier will take much longer to do because of the intensity of the work itself.
That's fair. I actually think it is quite clearly explained in the report. I'm not going to take you back to it, but I understand, and I think what you've just said is consistent with what you have in the report. Did Mr. Moore explain what he meant by current situation reflects the risk the city is willing to assume in respect of median barriers?
Not that I recall any explicit description.
Do you recall any discussion about risks around median barriers and risks that the city would assume?
Well, neither roadway had a continuous median barrier on them, the Link or the Red Hill. And so by definition, there was a risk present there that had been determined at the time of the design and construction of both of the roadways. So a risk had been assumed. There's always risk in transportation, and that was one that existed on both of the facilities.
Okay. Registrar, if you can close these call outs. And if you can call out the second bullet point on image 2. Did Mr. Moore explain what he meant by preferring the term potential solutions, quote unquote, instead of quote unquote recommendations?
Not that I recall explicitly. I think it's a reflection of that the city was going to consider the range of solutions, countermeasures that had been proposed, and make their own determination as to what to proceed with.
Is there a difference in your profession, in the consultancy that you do, between a recommendation and a potential solution?
I think it depends on the context that you use the words. I know in this report between edition 2 and edition 3, there was a change in the title of the section 9 from recommendations to options for consideration, I think it was.
Mm-hmm.
But in my view, that it didn't change anything at all. The entire content, essentially word for word, of the items that are listed is the same. So whether you call them potential solutions or recommendations or actions or countermeasures, I'm not sure it makes a difference if the items are all still listed there.
Okay. Would you agree that the term recommendation suggests that a consultant has applied their expertise to a range of potential solutions and come to select one as the recommended approach, or come to recommend several as the recommended approach in their professional judgment?
I think what matters is the list that is provided. And so the list of items, 10 countermeasures that were listed in that section of the report is the critical piece.
So so you don't agree that recommendation has a particular meaning, the one that I just gave you?
That could be one of the meanings. I'm not as fixated on the title of the section as I am on the content that was present. So the content which was there were the things that we suggested the city do. SEMA has no control over the actual implementation or not.
I understand that. That's going to be what this city staff assesses in their discretion and perhaps recommends to an appropriate committee. Is that fair?
What action they take with it is their choice, yes.
Okay. But for you as a consultant, you go through the long process that we've talked about, come up with particular preferred countermeasures that you then provide to the city. That's a recommendation, isn't it? Isn't it important to call it a recommendation?
Mr. Commissioner, if I may, I haven't intervened in a day and a half.
Yeah.
I think I haven't intervened once in a day and a half, but now I do, because I think the question is exactly the same that has been addressed previously.
I'm happy to move on.
Okay, thank you.
After this meeting that we're looking at on October 20th, did you learn any more about Mr. Moore's views on the draft SEMA report?
In preparation for this testimony, I was provided with various amounts of information that made me aware of some of the comments and views that he had, yes.
Just to add a bit of a boundary to my question, after this meeting and before March 2019, did you learn any more about Mr. Moore's views on the draft report?
No.
Registrar, you can take down this call out and this document. Thank you. Did you ever receive a copy of a document that had Mr. Moore's written comments, written edits or comments on the SEMA report?
No, I did not.
Did you ever discuss Mr. Moore's proposed edits to the report with anyone at SEMA who may have received them?
Well, I didn't know if anyone received them. I did not receive them, and I don't recall anyone discussing with me that they had received them.
Okay.
So no would be the answer.
During the meeting on October 20th, did Mr. White or Mr. Ferguson have any comments or any response to Mr. Moore's comments as reflected in the minutes?
I think the minutes would show if they did. So,
do you recall if Mr. Ferguson or Mr. White asked for clarification from Mr. Moore about the friction testing results that he mentioned?
I don't recall that, no.
What do you remember, if anything, about the tone of this meeting as between the city staff?
Between the city staff?
Yeah.
Nothing at all. I have no recollection of anything.
And what about generally the tone of this meeting with everyone in attendance?
no recollection, nothing comes to mind that sparks a memory.
Okay, so nothing particularly heated, acrimonious, nothing like that?
No, not at all that I recall.
Okay. Registrar, we are going to turn now to OD7, page 60, paragraph 183. Thank you. So you'll recall in, you were having that meeting over October 20th. On November 12th, Mr. Ferguson emailed you and attached a revised version of the staff report. So that's the city staff report summarizing the two reports, and says that they've attached the report. And with respect to the reports, there being the SEMA reports, we are asking that the wording that states recommendations be changed to options for consideration. Did he offer you any further explanation about the request for that wording change?
Not that I recall, nothing more than the content of this email.
Had you had any further discussions with Mr. Ferguson about the idea of changing SEMA's recommendations to options for consideration between the October 20th meeting and this email?
I don't think so. I know that the city staff were in the process of preparing a report to council, but I don't recall any other communication in that regard.
Okay. Yeah, and in the fourth paragraph, he says, you will see in the attachment identified short-term options and long-term options. Could reports have a similar layout? So that was attached. There was this attachment, and then there was also the report that's in the very first paragraph. Do you recall if you read the draft of the staff report that Mr. Ferguson sent to you?
I really don't recall having read it. It wouldn't have been for me to comment on or edit. It was a staff report. I'm sure I had an overview of it, but I don't really remember.
Okay. Registrar, can you take that call out down? And can you pull up CIM 9859 period 0002, the native form? Thank you, Registrar. Sorry about that. Registrar, just to make sure that we're looking all at this, because we've had some issues with native. Can you go to page 53, image 53, which is page 45? And if you can just hover over conclusion. So you see that's your colleague. And then if you can scroll down just a little, Registrar, and hover over options for consideration. So you'll see that's you, Mr. Malone, on November 20th. So this document reflects SEMA's inputting of Mr. Ferguson's comments. Do you remember actually going into the document and making these changes?
Yeah, no, I don't.
Okay. Registrar, can you scroll down to the next page, please? So there's some reference here to the high tension median, high tension cable median barrier system.
Are you able to flag for me whose comments are which? Who has made the comments? I see blue and red.
Yeah, so the I was attempting to do that with my reference before. The red is Mr. Hawash, and the blue is yours.
Okay.
And so you were content with making some changes to the high tension cable median barrier system section, consistent with Mr. Ferguson's request in that email that we just went through?
Well, I'm not sure it's all in relation to Mr. Ferguson's input, but we were reviewing again, so we were checking our wording. I know there were other wording changes that were made in conjunction with the change from the word recommendation.
Mm-hmm. Okay. And if you just look down to 9.1.2 at the bottom there, there's a change from is recommended to should be considered. And that is, that's your track changes. So
yeah, it's an intentional change, yes.
Yes, and so you were content to accept Mr. Ferguson's request to change words that speak to recommendation. So recommendations or is recommended to options for consideration or should be considered. You made some of those changes? Should
be considered has some very specific meaning in traffic and transportation engineering. The word should indicates that the action should be done unless there's a reason not to. So it's part of the reason for that change, or the use of that particular phrasing should be considered.
Okay. Registrar, can you go to page 50, pardon me, image 59, which is page 51. And so you'll see this is Mr. Hawash adding this in, but it is coming from Mr. Ferguson's email. And the proposal is to change, conduct pavement friction testing from a short-term timeline to medium. And Mr. Hawash says, I don't agree with the city, let's discuss. Do you recall discussing this with him?
I really don't recall the discussion. I know it was returned to short term in the version that was delivered to the city.
Do you know why Mr. Hadish or you made the decision not to accept that request to change from short to medium?
My recollection is that this is sort of a linked with the 2013 report where there had been a recommendation for friction testing. I had not been provided with information indicated that the city had done friction testing. And so we continued to include it on the list of countermeasures and elevated its importance with the use of short term.
Do you recall any discussion with anyone at the city about why you are not going to make that change?
I do not know.
Nowhere in this final report does SEMA reference the friction data that Mr. Moore sent you in August 2015, right?
The MTO data?
Any of the friction data that Mr. Moore sent you in that email?
None of that data was included because my understanding was it was MTO data not available for public release, and this report would have been public if it was sent to the city.
Do you agree it would have been helpful for your client, the city, to be reminded that there had been an earlier recommendation for friction testing and confirmation that you had not been provided, you city, this SEMA had not been provided with any reports analyzing the testing, that if it had been done, or at least any that you could use? Would that have been helpful for the city to have?
Well, you asked several questions. The
I
first
did.
one,
I did, and I apologize for that. If you can answer them, please do. If you need some clarification, please let me know.
if you can parse them out, that would be appreciated.
Sure. Do you agree that it would have been helpful for your client to be reminded that that SEMA had made a friction testing recommendation in 2013?
I don't think the city needed to be reminded. The previous report was less than 2 years before. It was still relatively fresh. There had been discussions with Gary Moore in August of 2015 regarding that exact issue. So no, I don't think the report needed to provide an explicit reminder of it. I think it was very clearly stated in the fact that it was in the report, the second report, as well as the first report. The reminder was the second report. It's for the action.
Did you attend the Public Works Committee meeting on December 7th, 2015, at which the city presented the 2015 SEMA report?
I was asked to attend, and I did attend, yes.
Thank you. Apologies. Before we close this document, this is a native version of a document in the OD, and I'd like to make it the next exhibit, which is Exhibit 61.
I'm sorry to interrupt, but you had several questions previously, but only clarified one of them. Did you want me to answer others?
No, it was just a complicated question, but when I rephrased it, you answered the question that I actually had.
Okay, thank you.
Registrar, you can close this document, and if you can go to OD 7, page 74, paragraph 223, please. And just bring it up. I need to call it out. Thank you. So this is in respect of the December 7th Public Works Committee meeting that you said you did attend, right?
I was present in the meeting, yes.
Registrar, can you call out paragraphs 233 to 235, please? So from a video of this, the overview document summarizes that Councillor Marula asked Mr. Moore, who was also present at the meeting, to elaborate on the quality of the asphalt used, asking whether the city used low-grade asphalt in comparison to that used by the MTO in constructing the Red Hill. And Mr. Moore replied that the city had used SMA which was a MTO's top mix. Mr. Moore also informed the Public Works Committee that the MTO had performed initial friction testing and received results at or above what MTO typically expected from high-grade friction mixes. He also referenced performance of subsequent testing and said he had no concerns about the surface mix. Finally, he said, in respect of whether the quality of the Parkway was different than any 400 series highway, that the Red Hill was above that grade. Do you have a specific recollection of this exchange between Mr. Moore and the councillor?
I recall Mr. Moore answered questions, but I don't recall the specifics.
Did you discuss this exchange that Mr. Moore had with the councillor with Mr. Moore after the meeting?
Sorry, with the councillor or with Mr. Moore?
Did you discuss with Mr. Moore the exchange that Mr. Moore had with the councillor after the meeting?
No, not to my recollection. I think I left the meeting immediately after it was done.
Did you discuss?
Sorry, I had been asked to attend to potentially answer questions regarding the SEMA report, and there were none.
Okay. Did you discuss Mr. Moore's comments at this meeting with anybody else at the city after the meeting?
Not that I recall, no.
Okay. Commissioner, I'm going to be moving on to another topic, and I see the time is 3:17. Would it make sense to take our afternoon break now?
My apologies, I was on mute. Let's come back. Let's take our break now. We'll return at 3:30.
Thank you. Council, can we, and Registrar, could you put council into a breakout room, please?
Sorry, Council, give me just one moment to reorganize the breakout rooms.
Thank you.
Welcome.
Mr. Malone, you said earlier that to your knowledge, SEMA used speed data in the 2015 report that had been collected in speed studies in 2013.
That was my recollection, that the data originated from collection done in 2013 or in advance of the 2013 report that we had completed.
Okay. And you said earlier you had no concern about using speed data that was a couple of years old in the 2015 report.
My preference would have been to use more current data, but that wasn't unacceptable. It was, as I mentioned earlier, with respect to speed, the speed profile wouldn't be expected to change as significantly as perhaps collision data. So it would be representative.
Okay. Do you recall that after the meeting of the Public Works Committee in December 2015, there was some controversy about the speed data that was set out in the 2015 report?
There were some questions. It wasn't controversial to me, but
Fair enough. And in particular, there was some questions raised about speed data showing 500 vehicles a day exceeding 140 kilometers an hour. You remember that?
I do, yes.
Okay. Registrar, I'd like to pull up CIM 9606, please. So this is an email from January 29, 2016, and it's from you to Mr. Ferguson. And it is the end of a chain of emails in which there is back and forth trying to clarify where SEMA got its speed data for the 2015 report. And then this is the email in which you respond about the data and about your views about the data. Did you investigate whether or not there was any reason to doubt the accuracy of the speed data that SEMA used in the 2015 report?
Yes, we went back and reviewed the information. There were a series of emails that went back and forth with the city regarding some other data collection sources that they had, trying to confirm the veracity of the data they used in our analysis. And I was satisfied that we had data that I had no reason to question, and therefore accepted the results from it.
Did that appear to satisfy the city on this point?
Depends who you mean by the city.
Mr. Ferguson?
Which one?
David Ferguson?
I think this email summarizes the thread sufficiently. I mean, I think the issue of the data had been addressed. I believe others agreed to disagree as to whether or not it was accurate. We were satisfied it was, and we didn't see any reason to make a change to the report. And I think Dave Ferguson was also satisfied with that investigation and the response that we had provided to the query. Okay.
And when you say others might have agreed to disagree, was that councillors who raised whether that seemed like a high number of high speeding vehicles?
Yeah, the question had been raised by Councillor Lloyd Ferguson and Councillor Whitehead. Both participated in a meeting that I was asked to attend to explain where the data came from and how the numbers which had been quoted in the report where they originated and how that could be the case. The basic concern was that Mr. Lloyd Ferguson, Councillor Lloyd Ferguson, was familiar with the enforcement activities by the police, and his information from the police was that they were not finding similar results. So we went through an explanation to how our data is collected, how it's different than the enforcement actions the police undertake, and why there might be variances and differences in the data points and such.
Okay. And just in terms of that last point, how your data is collected, am I correct that Pyramid is a contractor who will do a speed study over a period of time, 24 hours or 48 hours, and they'll do an assessment of the speeds of vehicles captured in the period of time that they are studying?
Yeah, they use equipment mounted on the road surface and measure any vehicles that go over that equipment for, as you say, a continuous period of time. I can't remember the exact duration, but I believe it was 7 days, if not 14 days. And that total quantity of data, in theory, collects the information on every car passing by. And so it's from my experience, we see that data, that type of data collected by companies like Pyramid and others using similar equipment to what Pyramid was using in studies across the country, really. So it's a very standard approach to gathering data.
Okay. In 2018, SEMA was retained to complete a speed study along the Link and the Red Hill. Do you remember that?
I do, yes.
Registrar, can you go to CIM 15996, please? This is an email exchange with one of your colleagues at SEMA and Mike Dorzak at Pyramid. Did you retain Pyramid to collect speed data for the 2018 speed study that SEMA was doing?
That's my recollection, yes.
To your best of your knowledge, did SEMA use the same collection process that we were just discussing in 2018?
Well, Pyramid would be the company, the contractor that would collect the data. And to my understanding is that he used the same methodology, the same type of equipment to gather this data, 2018, yes.
In general, how did the data collected in 2018 by Pyramid compare to the data collected in 2013?
I'm not sure I'm familiar enough with the details to be able to give you an accurate answer. I could research it, but I'm sorry, I don't have that available at the moment.
Maybe I'll ask the question differently. Did the data collected in 2018 by Pyramid cause you to reconsider the accuracy of the data in 2013?
Not to my recollection. The one thing I would highlight is when you undertake data using the types of tools that we're talking about, the on-pavement sensors, you can set up the collection into different, you call them bins, different formats. And I don't recall if the two formats were identical or if there was some simplification of the formatting in one or the other versions. The 2013 data included speed information separated out for speeds of 140 kilometers per hour and higher. I don't recall whether or not that was the case in the 2018 collection of data.
Okay, thank you. As a casual employee of SEMA, do you act as an expert in litigation involving road safety issues?
I get hired as an expert with respect to civil litigation matters on a regular basis, yes.
Do you currently act for the City of Hamilton as an expert in any litigation involving the Red Hill?
Mr. Commissioner, if I could just interject, I have a concern about the line of questioning that I believe Ms. Lawrence is about to ask Mr. Malone.
Just before you do that, perhaps we could ask the registrar to take down the current image so that I can at least see Mr. Letterman. Go ahead, Mr. Letterman.
Thank you, Mr. Commissioner. So as you know, Rule 42 of the rules of this inquiry provide that nothing is admissible in evidence at the inquiry that would be inadmissible in a court by reason of any privilege under the law of evidence.
Let me just stop for a second. Are you specifically objecting to this question?
This question, and I suspect the next several questions that Ms. Lawrence is about to put to the witness.
Rather than deal with this in a hypothetical way, let's deal with them question by question. So are you specifically objecting to the question, does he act as an expert for the city?
Yes, that one, Mr. Commissioner, and if you hear the other questions that Ms. Lawrence is about to put to the witness, you'll understand the context for my objection.
Well, I'm in your hands as to whether you want me to have Ms. Lawrence put the 3 questions so we have them before us, or we deal with them on a case-by-case basis. But I'm not going to deal with 1 question and 2 hypotheticals.
Well, I guess what my concern is, Mr. Commissioner, is before the witness answers the questions, I would like the opportunity to have you hear my objection, particularly as it relates to a concern about privilege.
Okay, well, is there any privilege question issue here with asking whether he has acted as an expert for the city in respect of safety, road safety?
That question in and of itself is, I have no difficulty with that from a privilege perspective, but it's the sequence that follows from that.
Well, I'm not going to speculate on sequence. If that you don't object to that question, then I think the question should be put, and the next question can be put, and you can address it, your next objection at that time. So Ms. Lawrence, why don't you put this question again to Mr. Malone?
Sure. Mr. Malone, do you currently act for the city of Hamilton as an expert in any litigation involving the Red Hill?
No.
Okay.
Have you been named personally?
Sorry, just let me.
Pardon me.
No. Okay. Okay, what's your next question?
Have you been named personally as a defendant in any litigation involving the Red Hill?
Now, I'll just stop for a second and ask Mr. Letterman whether there's a question of privilege there.
I've got no concern about that, and as to whether that is a relevant question for this inquiry, I will defer to you, Mr. Commissioner, as well as to Mr. Provost. But I've got no concern about privilege with respect to that.
Okay.
I assume it's public record. This is Richard Provost, so I have a really hard time seeing an objection.
Thank you, Mr. Provost. I concur in your legal analysis. Ms. Lawrence, you can put the question again to Mr. Malone.
Sure. Have you been named personally as a defendant in any litigation involving the Red Hill?
Not that I've been informed of.
Okay. Okay. Last question, Ms. Lawrence.
It wasn't just 3 questions.
I'm sorry?
There's a few more, but
I thought there were 3. Go ahead.
to your knowledge, Mr. Malone, has SEMA been named as a defendant in any litigation involving the Red Hill?
I assume there being no objection to that question.
No objection.
Mr. Malone, you can answer the question.
Not to my knowledge.
Okay.
Mr. Malone, are you personally a party to any joint defense agreement, cooperation agreement, or tolling agreement with the city of Hamilton?
Mr. Commissioner, I have a trouble with that question.
Okay.
So
I'm just going to get the full question. Party to any joint defense agreement, tolling agreement. What was the full question, Ms. Lawrence?
Are you personally party to any joint defense agreement, cooperation agreement, or tolling agreement with the city of Hamilton? And perhaps just as a matter of efficiency, my next question, to which I also expect an objection, is, to your knowledge, is SEMA a party to any such agreement?
Okay,
I have the same objection to that question.
yeah, of course. So, Mr. Letterman, I'll hear your submission.
Thank you, Mr. Commissioner. In late February, I had an exchange with Commission Counsel in which I was asked, as counsel for the City of Hamilton, as to whether or not the City of Hamilton had entered into any tolling agreements, joint defense agreements, cooperation agreements with respect to any anticipated pending or existing litigation involving the Red Hill Valley Parkway with respect to any of the participants in this inquiry or with SEMA. At that time, I advised Commission Counsel that it was our view that that information is privileged and in any event was not relevant to the terms of reference in this inquiry, but most importantly is privileged. As you know, Mr. Commissioner, I act for the City of Hamilton in this inquiry. I do not act for the city in connection with the existing litigation that is carried on, but it is my role to ensure that privilege is safeguarded through this inquiry process, and so that information is not improperly divulged that will betray a privilege that exists in connection with existing litigation or anticipated litigation involving related matters on the Red Hill Valley Parkway as against the City of Hamilton. I advised Commission Counsel of our position that this was privileged, and on March 18, Commission Counsel wrote to us to advise that it would consider our position and would get back to us. Commission Counsel never came back to us to advise that it had disagreed with our assertion of privilege until last night, in which we were advised that Commission Counsel intended to ask these questions of Mr. Malone during the course of his testimony today. This is not information that is contained in any statement of anticipated evidence. It is not information that is contained in the overview document. And what I'm concerned about, Mr. Commissioner, is that this is in effect an attempt to circumvent or do an end run around the city's assertion of privilege over whether or not it has tolling agreements and the like in connection with litigation involving the Red Hill. And in my respectful submission, the appropriate way to have that question adjudicated is on a proper motion in which I can provide to you the legal authorities that show that only in limited circumstances where the landscape of litigation has changed by virtue of the entering into of such agreements, that there is a common interest privilege that would attach to any such tolling agreements and whether or not a litigant has entered into any such agreement. And so it's for that reason that I'm raising my objection and having regard to the fact that obviously privileged information is not admissible in the course of an inquiry. And so I would suggest, with your indulgence, that if this is a line of questioning that Commission Counsel intends to pursue, not only with respect with Mr. Malone, but also with respect to any other participant who is going to come to testify, then I would appreciate the opportunity to have that question properly adjudicated on a proper record so that you have the authorities before you, or perhaps in front of a delegate to have that matter properly adjudicated before the evidence is led from this witness or any other witness. Now, I recognize that Mr. Malone is here today, but he is scheduled to come back for another round at a later hearing block, which would certainly allow for an opportunity to deal with this issue before that testimony or that issue is raised.
Let me ask, I take it that your real issue is privilege, not relevance.
Well, my most significant issue in terms of why it is that I'm rising now before any answer is delivered is yes, because of privilege. Obviously, relevance is something that you can weigh. But my bigger concern is privilege, given that the rules are quite clear that the privilege information is inadmissible.
Let me ask Mr. Provo, does your client object to answering the question?
Mr. Commissioner, no, he doesn't object. I have a hard time seeing that other party would have a privilege with regard to a witness that's not their employee or anything. Also, if the answer is no, how can it be privileged? There's no relation. There's no existence of a document.
Mm-hmm.
If indeed the answer was yes, and the question was asked, okay, can I see the agreement? That is a different story.
But, Mr. Commissioner, if I may just reply to that, that's
no, I want to let Mr. Provo complete any submissions he wishes to make first.
Oh, I'm sorry. I thought he had completed. Pardon me.
I did, my lord, Mr. Commissioner, I did.
That's quite all right.
You wear both hats, so it's okay.
In this, I only wear one hat, Mr. Provo, and it's a hat which is slightly different from the one that I wear in court. And
I understand that.
I think it's important that we all understand that. Let me just make a note here.
My answer is the same for the complementary anticipated second question.
Thank you.
For which the attorney Lawrence is expecting an identical objection.
Thank you.
So, Mr. Commissioner, if I may just...
Well, I think I should allow Ms. Lewis to respond, and then I will allow you to reply, Mr. Letterman.
Thank you.
Thank you, Mr. Commissioner. First, and I am reluctant to do this, but Mr. Letterman did not, in my view, fairly set out the discussion between Commission Counsel and his office. And to be clear on the record, Commission Counsel and Counsel for the city did have discussions about this. Commission Counsel was very clear that that we did not agree that this was not relevant, and it was our position that it was not privileged. And the last of that communication was that we would consider the position, but Commission Counsel's position was very clear. And Mr. Letterman is exactly correct that I last night provided notice to the parties of Commission Counsel's intention to raise these questions today, having very recently received anticipated evidence in respect of the questions and the answers that I propose to ask. Commission Counsel's view is that issues around joint defense agreements and cooperation agreements in particular are very relevant to the assessment, to your assessment of the credibility of witnesses.
Mm-hmm.
Second, Commission Counsel's position is that agreements, at least as we have before us right now, any potential agreement could not be privileged if the common interest privilege is the privilege that is being asserted. And if Mr. Provost has confirmed that he has no objection, there is simply not a privilege to be asserted. Third, I have not heard Mr. Letterman say that there is some independent privilege that the city has that is attempting to maintain, nor that there is some agreement or obligation that SEMA has that would prohibit them from providing the answer to the question that I've asked. In Commission Council's view, it is appropriate for this matter to be before you, Commissioner. It is unnecessary to go before a delegate. And I have given notice to all council that Commission Council does anticipate asking these questions. And certainly we can continue to have objections and make submissions on facts, depending on, on the witness who is being questioned. But for this witness in these circumstances, it's Commission Council's view that it would be appropriate for you to conclude that it is not privileged because there is not an assertion of privilege that is being clearly identified, and it is entirely relevant to the work before you. Those are my submissions. Thank you.
Mr. Letterman, before you address your reply, I want to distinguish between this particular witness and the other cases, knowing well that, I guess you've already expressed it yourself, but it would be expected that you're raising this because this is the first time this question is being put to any witness, and you will potentially object to others if not this witness. I want to say that insofar as there are others who express a concern for privilege when the question is put to them, I agree with you that this should be the subject of a formal motion, which we'll have to build into the process. I'm having trouble seeing how we need to address that at the present time in respect of this witness who has raised no objection. And any reply that you wish to make should be put in that context.
So let me reply to that then. And that's exactly the mischief that I want to avoid by allowing for this question to be asked of this witness. Then we get to the next witness before we've actually had the legal question properly adjudicated. In other words, in my respectful submission, Mr. Commissioner, it would not be appropriate to one by one go through the participants and ask this question, and only those that assert the privilege is just a way of identifying which parties, if any, have entered into a tolling agreement or the like. And that can't be a fair way of dealing with the question as to whether or not the city has the right to validly assert privilege over the existence or the content of any such agreement that it may have with any participant in this process in connection with the ongoing or pending litigation involving the Red Hill Valley Parkway. In other words, I appreciate that Mr. Provost doesn't object to this witness answering that question, but the implication of allowing the witness to answer this question before the matter has been adjudicated is it preordains the results so that the inference can be drawn if and when we get to a witness who does object to that information being raised. And that's precisely why, in my respectful view, if this is the line of questioning that is intended to be asked, we need to sort out whether or not privilege applies to this first. If the answer is no, that there is no privilege associated with it, then absolutely any witness can be asked. But to do it in a piecemeal way, in my view, would be unfair and just erodes the question of privilege before we've had an adjudication on the point.
All right. 4:01 today.
Mr. Commissioner, with your permission,
Yes.
I would like to add the following. If we push this situation to an extreme, a party to a inquiry like this one could impose NDA, non-disclosure agreement, on various witnesses here and there that would unfortunately deprive you of a complete appreciation of their credibility. That alone, I believe, is sufficient to dispose of the objection.
Mm-hmm. Well, I will say for the benefit of counsel, I think that comment is directly relevant to the issue of relevance. And I'm having trouble seeing how this is not a relevant question. This is not litigation, as we said a moment ago. So the role of the judge is not at play here. In litigation, the judge would be limited to the evidence that the parties wish to put before the court. This is different insofar as the commissioner is mandated to attempt to understand the facts. And an important consideration in respect of that is whether the participants who appear before the inquiry are in fact not independent, but are in fact aligned and are giving the same story. And that certainly goes to credibility. I think that's what Mr. Provo was alluding to. So I'm having trouble seeing how this is a question. There's a legitimate question of relevance. With respect to the question of privilege, Mr. Letterman, I don't understand the concept of common interest privilege in the context of a situation where the party to whom the question is being put has no objection to answering it.
No, well, perhaps let me address, before we talk about the common interest privilege point, let me address the relevance point. I would agree with you, Mr. Commissioner, that it may be relevant and would be relevant if there were such an evidentiary arrangement in place in the context of an inquiry. And indeed, I think there are some cases that deal with that. That is very different than asking whether a tolling agreement or other types of standard joint defense agreements are in place in connection with related litigation involving the subject matter. So that's my answer to the relevance point, which we can address separately. But quite apart from relevance, the privilege issue is that the privilege exists in connection with both litigation privilege, in which a party to litigation not infrequently can enter into tolling agreements, joint defense agreements with either co-defendants or potential third-party defendants in that litigation. And that is a privileged agreement, and the circumstances in which a party to litigation may enter into those agreements are subject to both litigation privilege and solicitor-client privilege, as well as common interest privilege. And so whether or not a party has actively engaged in that type of agreement, that's a privileged question. And in my respectful view, that should be adjudicated before peeling off one witness after the next, saying, well, do you have any such agreement in place in connection with the litigation involving the Red Hill Valley Parkway? And so I only ask, let me just finish by this point.
I'm just trying to understand what the common interest privilege is that's being asserted.
So if a party to litigation has entered into a tolling agreement or a joint defense agreement, even though they may have positions that are adverse vis-a-vis the plaintiff in a piece of litigation, they share a common interest in defending or preserving a tolling agreement or any such agreement in connection with that plaintiff. That's how a common interest privilege.
I fully understand that. I'm having trouble understanding how the fact that they have entered into such an agreement as opposed to the contents of such an agreement is privileged.
Well, the fact of whether or not they've entered into such an agreement is equally, in my respectful submission, also privileged, just as did a party seek legal advice. That equally would arguably be subject to privilege, not just the content of that advice, but whether or not they've sought legal advice.
So this is not the occasion in which perhaps to engage in that debate. But if that's the context in which you assert the common.
Well, I'm just trying to, what I'm trying to suggest, Mr. Commissioner, is this is an issue that I view that you would benefit from being briefed. And I don't think, given that Mr. Malone is scheduled to return, that there was any prejudice to having this issue properly brought before you to be adjudicated before these questions are asked.
Okay. Before I make any sort of decision, do any of the other participants wish to speak to this matter?
Recognizing Ms. I'm not sure if Ms. Roberts is about to unmute. I see her on the screen. I do have one final set of submissions. I know we've done, I think, 2 go-arounds, but
I just wanted to hear from any of the other council before
Okay.
I gave you the opportunity to
thank you.
make your final response. I'm taking the silence to be a negative. Okay, Ms. Lewis.
Ms. Lawrence.
I'm sorry.
It's okay. You had 5 weeks with Mr. Lewis. So it's fair enough. I do see Ms. McIver is on the screen.
Ms. McIver?
Hey, I'm sorry, I have nothing to say at the moment.
Okay.
I just thought that I would turn on my camera in the events that I do moving forward.
Okay, thank you.
Thank you.
Ms. Lawrence.
Thank you. In respect of the issue of whether this should be before you by way of a motion or by way of a proper briefing, as I think is how Mr. Letterman characterized it. In my view, where a witness objects themselves to a question, either individually or by counsel, it would certainly be beneficial for you to obtain fulsome submissions from that person and any other entity who may share in the same position as the objector. I would anticipate that we may have such circumstances, and those can be dealt with, I think, quite differently than the issue before you today. I would categorize Mr. Malone and Mr. Provost's lack of objection to any issue in answering the question as evidence that there is no privilege that Seema or Mr. Malone themselves are asserting. And I have not heard an articulation from Mr. Letterman about the assertion of privilege that the city is independently claiming. So in my view, you can absolutely hear the relevant answer to this issue without a motion on this issue. And to the extent that there are other witnesses who object to that issue, I would anticipate and hope that among council, we can have discussions before that happens on the record, and we can come and prepare appropriate motion materials and briefs for you at that time. But for today, in the circumstances of this witness and his counsel, I simply don't see why it would be deferred. Thank you.
Well, Mr. Commissioner, can I just reply to that?
Before you reply to that, and I don't think I need a reply, I simply want to understand exactly what kind of motion we would have. It would be a motion, as I see it, as to whether or not there could be some kind of common interest privilege asserted by the city in circumstances where a participant does not assert such a privilege or any privilege.
I would
understanding.
I would imagine the motion would involve the very request that I received from Commission Counsel on February 25th, which was to advise as to whether or not the city of Hamilton had entered into tolling agreements and the like with any of the participants.
That is not what's before this court, and not what I would envisage in terms of any motion. I say again, the issue before this tribunal is whether the city can assert an interest, privilege, in circumstances where the questioned party does not.
I have to go by the rules of this inquiry, Mr. Commissioner, that says nothing is admissible in this proceeding by virtue of something being privileged. And so the question that was put to me as counsel of the city of Hamilton was to disclose the existence of any such tolling agreements. The city of Hamilton has taken the position that if it has tolling agreements in place involving litigation, involving the Red Hill Valley Parkway, that such agreements are subject to privilege. And so I would have thought that the motion before you is to determine whether or not any such tolling agreements in connection with that litigation are indeed subject to privilege.
Let me just make a note. Okay, I am going to take this one under advisement overnight, and I will advise the parties tomorrow morning of my decision with respect to Mr. Letterman's position. In the meantime, we still have some time left, and I think we should proceed to the first. If Ms. Lawrence has no other questions.
I just have one housekeeping matter. The very last exhibit that I raised with Mr. Malone, I did not mark it as an exhibit, and I should have. This is CIM 15996. We don't need to pull it up again. I just like to mark that as the next exhibit, as I understand it's not in the overview documents, and that is exhibit 62. Thank you. And subject to the commissioner's ruling in respect of the questions that I have put on the record that I'd like to ask, those are some of my questions for you, Mr. Malone. Thank you very much for your time and attention today. Okay. Commissioner, I understand I've spoken to council about timing, and I understand that MTO anticipates being quite short in its examination, 10 minutes or less. which would fit us in still before 4:30. So subject to Ms. McIver's view, I think it would make sense to turn to her first. And then we can discuss before we end for the day the process for tomorrow, if you would like.
Okay.
Hello, Commissioner, and Ms. Lawrence, that's right. I still understand, I still expect to be quite short, quite brief. Mr. Malone, I'm Heather McIver. I am counsel for MTO. And Mr. Commissioner, if I might proceed.
Please do.
There was discussion today, Mr. Malone, about the 2007 MTO testing results that were provided to you by Mr. Moore. And you mentioned that they were not included in the SEMA report because you assumed that MTO did not want them distributed. Is that right?
Well, they were provided to me by Mr. Moore, and his notation indicated to keep them confidential. So my understanding was they were not materials from the city of Hamilton. They were MTO materials, and so I didn't have MTO approval to utilize them, include them in a report, or otherwise make them public. So that's why I didn't. Okay,
fair enough. But I just wanted to clarify, you didn't speak to anyone from MTO regarding these results and regarding their views about their distribution. Is that fair?
That's correct, yes.
Okay, and I believe it's been clearly stated by your answer to my last question, but you received them from Mr. Moore, and it was Mr. Moore who requested that they not be published. Is that correct?
Yes, consistent with the email that was displayed earlier today and the wording that was in that email. Yes.
Right. Okay. And so by virtue of the fact that he was providing them to you, you would have been aware, presumably, that MTO had already released them to the city. Is that fair?
Well, the thread was from Golder, and Golder had sent them to the city. So I'm not sure how the chain of ownership existed, but it was Golder to the city and the city to me.
Right.
And they were included in the Golder report. So I don't really know the origin in the Golder report.
And that's fair enough. But somehow they were before they came to you, they were in the hands of Golder and the city. Is that right?
Correct. Yes.
Okay. Thank you. Those are my questions for you, Mr. Malone.
Okay. Ms. Lawrence.
Commissioner, I anticipate that I've heard from Ms. Roberts that she will be about half an hour, and from the city that they will be about an hour. So although we have a few minutes left before 4:30, I would propose to adjourn early and start with those cross-examinations tomorrow morning.
Okay. We will do that. And then we have Mr. Appleby coming in. Is that correct?
That is correct. I had asked for him to be available by 1 p.m. and I'll ask if I can have him attend even earlier so that we can move smoothly through tomorrow.
Okay, good. I'll leave you to speaking to council about that, and we'll then stand adjourned until 9:30 tomorrow morning.
Thank you.
Thank you.
Thank you.